All right. Today we have day 4 of the preliminary hearing of Tyler Robinson, the accused assassin in the Charlie Kirk case. So we're going to go and take a live look into court and just watch along live.
And I think you testified earlier. What was your primary assignment?
My primary assignment at the campus, as well as throughout the case, was to oversee the crime scenes as well as the physical evidence.
Before you could do your work on the crime scenes, did the campus have to become secure?
Yes, it did.
And did that involve making sure there was no active shooter on campus?
Yes.
And did that involve officers searching buildings and clearing buildings throughout campus?
Yes.
You mentioned that were there multiple areas that were processed by you and other crime scene analysts in this case?
Yes, there was. Would you like me to go over them?
Let me direct you to a few of them. Well, yes, please mention the scenes.
Yeah, so one scene was a courtyard area, or I guess what we could also refer to as the amphitheater where the event took place. The other scene would have been the Fulton Library, where there were 2 bus stops. And then another would have been the wooded area. And then the last one would have been the Lolosi Center building, as well as the ground below.
All right, let's start with the rooftop. What was who was assigned to process the rooftop area?
The team that was assigned to process that was the Utah Bureau of Forensic Services, or also known as our state crime lab.
And generally, what does processing an area involve?
Processing includes documentation, sketching, as well as taking photographs, marking, as well as labeling evidence, and then determining how to package them properly, as well as also just trying to ID anything probative.
On the rooftop was evidence found?
Yes.
What types of evidence were found on the rooftop?
One item of evidence that was found was a screwdriver. Another one would have been what we believe was the shooter's perch. That was determined that was easy to see at night. Using oblique lighting, we could see disturbances in the gravel on the rooftop. And then on the northeast edge, our team also found some swipes on the ledge of that rooftop that was also collected.
Okay, so northeast ledge. And is this the dropping off point?
Yes, it is.
You said swipes. What does that mean, swipes?
Swipes is, I would describe it as kind of hand marks or any type of marks that is left by something that causes some type of disturbance.
Okay. And where on the ledge were those located?
Those were located right on the edge of that right on the edge of that rooftop. And then right below, we also had some other swipes as well as some other impressions. And then below that was a glass window where we also located some latent prints.
Okay, I want to return to the what you've referred to as the perch, the sniper position. Were measurements taken from that sniper position to the tent where Charlie Kirk was seated?
Yes.
Do you know the distance?
Yeah, so the distance from the perch area directly to the tent where Mr. Kirk was sitting was approximately 415 feet. If you break it down, so from the perch to the
And they're showing the top square. That's the perch where the alleged shooter was. And then the bottom square, that's where Charlie Kirk was sitting when he was shot. They've dropped the audio here for some reason. I'm not sure. It's being redacted. There's certain parts of this hearing that they're not showing to the public. There's been motion after motion, including this morning, where they were discussing what can be allowed in and what can't be.
To the tent with a 68-foot vertical drop. Is that right? On the rooftop, were shoe impressions found on the rooftop?
Yes, there was.
Did those who processed that area of the crime scene collect the latent prints and the shoe impressions that you've talked about?
Yes, they did.
And this is a good point to read a stipulation into the record.
All right.
The language of this has been agreed upon by the parties. The parties stipulate that investigators at the crime scene observed latent fingerprints and a palm print on a glass window near the area where the individual landed when the individual jumped from the rooftop of the Low-C Center at UVU. SBI fingerprint examiner Elisa Farmer examined images of these latent fingerprints and the palm print and determined that only 3 of the latent prints, 11B, 11C, and 11D, were of comparable or of poor comparable value. She excluded Tyler Robinson as the source of any of these 3 latent prints. Ms. Farmer reviewed other prints on the window and found that they did not have adequate value for comparison. Subsequent examinations of these 3 latent or actual latent prints by the FBI were inconclusive. That area that was described in that stipulation, is that the area in the glass window that you're talking about?
Yes, that is.
That's on the northeast corner of the Low-C Center.
Yes.
And that's the area where we see in a video an individual drop from the roof.
Yes.
I want to move on to another area, the courtyard. First, will you describe what that area of the crime scene looked like?
Yeah, so when I arrived on scene, you have different steps. I believe there were maybe like five or six covered in grass. When I was there, there were personal belongings spread throughout. There was a tent towards the west end of that courtyard area, as well as some banners and some barriers as well.
Was that area processed for evidence as well?
Yes, it was.
What was done to process that area?
Photography, as well as just examining the tent area to see if there's anything there.
And who is assigned to process the courtyard area?
The FBI.
I want to take you to another area, a wooded area. Was there a wooded area that was processed as well?
Yes, there was.
Will you describe first off where that area is?
Yes, so this area is located northeast of the Low-C Center building, and it is across from Campus Drive.
Your Honor, could we publish Exhibit 35, please? Yes. And if I may approach the witness, I'll put up the hard copy of this exhibit as well.
All right. While they're preparing this exhibit, unless I heard incorrectly, I believe the party stipulated that the fingerprints found on the window did not belong to Tyler Robinson.
Can we publish the?
That's
Thank you.
one of the first pieces of evidence that's in the defense's favor.
Right on the screen in front of you. Will you take a look at Exhibit 35?
Yes.
Do you recognize that?
Yes, I do.
Will you take a moment to orient yourself on that map and tell me when you've found the relevant points that help you understand what this map is of?
Yes.
Do you see the courtyard on that map?
Yes, I do.
Kimberly, can you zoom in to the courtyard area, kind of the center of the, there's a pointer on the screen. Is that the courtyard?
Yes, that is.
All right, now the Low-C Center, will you describe, well, let's jump to the wooded area. Where is the wooded area that you're talking about, seeing that was processed?
Yep, the wooded area, if you go from the courtyard and you go northeast, you're going to come across this big parking lot. And then if you just go directly north to that.
Okay, at this point, it might be easiest for you to actually indicate on the physical map. If you don't mind just standing up, give you a handheld mic.
Yes, so the wooded area is approximately right here in this area.
Okay, so just to make a record of the area, on the northern, I guess I'll say, and north is up on this map, is that right?
Yes.
Do you know where Campus Drive is?
Yes, Campus Drive is this road that winds right along here.
Okay, and so that's kind of the windy road that begins in the upper left-hand corner of the exhibit and winds down through the center of the map and kind of exits to the middle right side of the map. Is that right?
Yes.
And the wooded area, where is it in relation to the Campus Drive?
It is north of Campus Drive.
Okay, kind of in that probably the center right of the map. Is that right?
Yes, that's correct.
Will you describe, first off, what is on the south side across the street from the wooded area?
Yeah, so on the south side of the south side of the wooded area, we have the computer science building, which is to, I guess, east. And then we have a parking structure, and we have a walkway along here in between that connects the computer science building and the Veloci Center building. And then right onto the southwest of the parking lot area is going to be the Veloci Center building.
Okay. Now you referred to the area across the street from the wooded area as a parking structure. That's a parking lot, right?
I'm sorry.
And there is a parking structure on campus, correct?
Yes, there is.
But that's different than the parking lot you just mentioned.
Yes.
Okay. All right. Back to the wooded area. What was found? Was anything found in the wooded area of evidentiary value? You can sit down. Thank you. You can take that.
May you repeat your question?
Was anything of evidentiary value found in the wooded area?
Yes, in the wooded area, a rifle that was wrapped in a dark colored towel was found there.
And how did you learn about that?
I found that out because just a little bit before 6 p.m. that day, I received a call from Utah County Sheriff's Office, who was tasked with searching that area.
Do you know why they searched that area in the first place?
Yeah, so they searched that area because I received a video that was from the UVU security footage. This was received by our command post on scene, and it showed who we believe was the shooter on the rooftop run from the southwest corner all the way to the northeast corner, jump down, and then continue to the northeast side of that campus, and then cross the street to Campus Drive, and then the suspect was out of camera's view after that.
Okay, so he ran basically toward and into that wooded area,
Yes.
right?
And there you can see the pathway from being on the roof, and then where the suspect ran across, dropped down, and then ran across the parking lot to the wooded area where eventually the gun was found, the rifle.
Yep, what I
Wrapped.
saw was a rifle that was, or at the time before even having removed it, we found, or in the bushes, we found all you could really see was just a dark towel there. So pictures were taken of that, and then eventually the gun or the towel was removed. And then once we removed the towel from the bushes is when we uncovered that the towel was actually used to wrap the gun in.
Have you reviewed State's Exhibits 10, 10.1, 10.2, and 10.3? Do you remember reviewing these?
Yes.
And are they accurate photographs of the weapon when it was recovered and shortly thereafter?
Yes.
I move the admission of State's Exhibits 10, 10.1, 10.2, and 10.3.
Defense? All right, and as it relates to publication, if any?
Yes, I would ask that these be published at all three levels.
All right, any input, Mr. Burt? All right, I'll note the standing objections from defense. Those are overruled. And 10.10, 10.1, 10.2, 10.3 are admitted into evidence and may be published both in the courtroom and through the use of the camera.
If we can please publish number 10, thank you. You have in front of you on the screen Plaintiff's Exhibit 10. Will you describe what we're looking at here?
Yes, what we are looking at here is actually the bushes where the dark colored towel and the gun were found. You can kind of see the dark colored towel towards the right-hand side of the screen in the middle, right middle.
Kimberly, can you zoom into that area, please? All right, is this a better view of the towel?
Yes, it is.
If we can go to exhibit 10.1. Will you describe what we're looking at in exhibit 10.1?
Yes, this is a mid-range shot of, again, the towel that was used, or of the towel and within the bushes.
All right. When this was found and you arrived on scene, what happened with that weapon?
We moved it from the bushes, or say FBI Special Agent Kamak moved it from the bushes. We then placed it on a cardboard box, took pictures of it, and then we removed the towel, packaged the towel separately, took additional pictures of the gun, and then rendered it safe on scene.
Okay, I'll ask you about that more in a minute, but let's go to number 10.2. Will you describe what we see here?
Yeah, so what you see here now is the dark colored towel and the rifle that is in the towel, and it is in a cardboard box.
Why is the towel still around the gun?
We wanted to document as to how it was found.
All right, let's go to 10.3. Is this the rifle?
Yes, it is.
You described making the rifle safe. Will you describe what that is?
Yep, so what that is that we ensure that there isn't anything in the chamber and that there's no other cartridges in the gun that would have it go off. So to do that, because it is a bolt action gun, we would have to manipulate the bolt or the lever back, and then from there see if anything was in the chamber, and then let's say carefully remove anything that was in the chamber and below it.
All right, what is the difference between a bolt action and an auto ejecting gun?
Yep, a bolt action is one where the user actually has to manipulate the bolt. So they would actually have to turn, or they would actually have to pull it back and forward to, whether it be to load it, lock it, as well as extract anything that's in it. Unlike a semi-auto gun, that is one, every single time you pull the trigger, a bullet will be fired, and then from there, a casing will be extracted out, as well as a new cartridge will then be automatically fed into the chamber.
So if you shoot a bolt action rifle, does that spent shell casing automatically exit the gun?
No, it does not. It will stay in there until the person that is handling the gun actually removes the bolt, or actually pulls the bolt back. .30-06 cartridge case, or say a fired cartridge case, and we also found 3 unfired cartridges, all with engravings on them.
Okay, I want to make sure we understand the language you're using. When you say cartridge case and you say cartridge, what do you mean?
Yep. So a cartridge is basically the round itself, right? The whole round. And the round consists of the cartridge case, and then the powder, and then the bullet on top. So the cartridge case, the term is used for something that has been fired already. A cartridge is an unfired round.
Okay, cartridge is the unfired round that still has the bullet, the powder, and all that.
Yes.
Cartridge case is the fired, is a round that has been fired and it's just the empty brass casing, is that right?
Yes.
Okay. Was there any, so there was, I just want to make sure I understand, a fired cartridge case and 3 unfired cartridges.
Yes.
Was there anything distinctive about these items?
All 4 of them had engravings on them.
Did you observe those engravings?
Yes, I did.
Did you observe them right there on scene?
Yes, I did.
And what was done with, let's talk about each of those things. First, the towel. What was done with the towel?
The towel was packaged it was packaged and then it was eventually provided to the FBI.
What was done with the firearm?
The firearm was also packaged and then provided to the FBI as well.
Did the firearm go to the FBI or the ATF?
Oh, sorry, correction. First it went to the FBI and then to be in their custody, and then it was then sent to the ATF lab.
Okay. And the rounds, the cartridge and cartridge cases,
Yep.
cartridge case.
Yes, all those were packaged, originally provided to the FBI, then was sent to the ATF lab.
Right? And were each of those items tested?
Yes, they were.
And in the testing, were they photographed?
Yes.
Have you reviewed the photo and were they photographed by the ATF when they were tested?
Yes, they were.
Have you reviewed their photographs?
Yes.
And were you previously shown states exhibits 19, 20, 21, and 22?
Yes.
And are those photographs that the ATF or that you received back from the ATF of those cartridges and the cartridge case?
Yes.
Did they have the same appearance and etchings that you saw when you observed them removed from the gun?
Yes.
And did those photographs accurately capture those etchings?
Yes.
I move to admit states exhibits 19 through 22.
Mr. Burt. All right, I'll note the standing objections. Those objections overruled, and 19, 20, 21, and 22 are admitted. And as to publication, Mr. McBride.
I would move to publish these exhibits at all three levels.
All right, any further objection from? Thank you. Again, I note the standing objections as are overruled. They may be published both in the courtroom and captured by the media camera.
Let us start with exhibit 19, please. What are we looking at here in exhibit 19?
This is the cartridge case that was recovered from the gun.
And what position was this in the gun?
This was this is what was in the chamber.
Okay. In the chamber, meaning that's where a cartridge is before when it is fired, correct?
Yes.
Do you notice an inscription or an etching on this cartridge case?
Yes, I do.
Will you read what that says?
Yes. Notices bulge.
And if we can go down to page 2 of the exhibit, will you read what this says?
OWO, what's
And to page 3
this?
and question mark, correct?
Yes, question mark.
All right, if we go to State's Exhibit 20. Is this a photograph of one of the cartridges that was found in the gun?
Yes, it is.
And what are we looking at here in this view of page 1 on Exhibit 20?
This is the head stamp of it, and it says it is according to the head stamp, it is a Remington 30-06 Springfield.
Is that a different caliber than the .223 round?
Yes, it is.
Will you look at page 2 of Exhibit 20? Will you read the markings here?
A fascist,
And page 3?
catch,
And page 4?
up arrow, right arrow, down arrow, down arrow, down arrow.
All right, let's go to Exhibit 21. And was this another round that was found in the gun?
Yes.
Will you read the inscription here?
O Bella Chow,
Page 2.
chow chow.
All right, let's go to Exhibit 22. another round that was found from the gun, correct?
Yes.
Will you please read the letters here?
If you read,
Page 2.
this comma, your, or correction, this comma, you are
Page 3
gay,
and page 4.
LMAO.
Hmm. So Bella Ciao is an anti-Nazi, anti-fascist Italian folk song. Wow. And that's what was inscribed.
Did you go to
on the
St.
bullets
George?
there.
Yes, I did.
And what was your role in St. George?
My role was overseeing the execution of the search warrants at both Mr. Robinson's residence as well as his parents' residence.
And we've had testimony that Mr. Robinson was arrested there. Was he fingerprinted and his DNA taken?
They were actually taken at the Utah County Sheriff's Office jail.
After he was transported to
Yes.
Utah County? Okay, you said that there was, were items of evidence collected from him after he was arrested,
Yes, there was.
from his person? What were those things?
They were his clothing that he was wearing at the time of his arrest, to include shirts, pants, underwear, as well as shoes and anything that were in his pockets.
Do you remember what tops he had on?
I believe it was a maroon top.
And was there any other top layer that was collected that you recall?
I don't recall.
Let's go to, you said there were a couple of homes that were searched there, is that right?
Yes.
Whose homes was that?
One of them was where Mr. Robinson and Mr. Twiggs resided, and the other was Robinson's parents' residence.
I want to ask you about the defendant's home. What items will you describe some of the items that were collected from that home?
Some items collected in that home were a Dremel tool and its bits container, as well as two Remington boxes of 30-06 ammunition, as well as some 30-06 cartridge cases, and a handful of long guns or rifles, a revolver, as well as a burned paper.
All right, I want to ask you about clothing as well. Was any clothing collected from the townhome?
Yes, there was.
How about shoes?
Yes.
What kind of shoes?
Two shoes were collected from the home. One was a Converse shoes, gray in color with white laces, I believe a size 10.5. And then another Converse shoes that were also gray, but had gray laces instead, but were of a different size that I can't remember.
I think you said that you collected boxes of ammunition. Do you remember what caliber that ammunition was?
Yes, there are a handful, but the one that I recall was 30-06.
And you also said you found some cartridge cases. Do you remember what caliber those cartridge cases were?
Yes, those were also 30-06.
If we can display just to the witness Exhibit 23. Do you recognize Plaintiff's Exhibit 23?
Yes, I do.
And is that an accurate photograph of the cartridge casings and some of the bullets that you found?
Yes.
I would move the admission of Plaintiff's Exhibit 23.
Mr. Byrd?
No further objections, Your Honor.
I'll note the standing objections by defense. Overrule those objections and admit into evidence State's Exhibit 23 as to publication, Mr. McBride.
I would move to publish at all 3 levels.
All right. It is published to the courtroom as well as maybe broadcast via the camera.
As that's coming up, where did you find these?
I found these in what we would consider the spare bedroom, right next to Tyler's bedroom, on top of a safe.
How do you know which bedroom was Tyler's bedroom?
We determined that based off of some documents we found in what we believe was Tyler's bedroom, such as mail that was addressed to him, as well as some school documents as well.
And again, in relation to, will you describe the layout of the house in that area?
Yep, so this was on the second floor. As you're coming up the stairs, if you turn the left up the stairs, you're going to run into 2 bedrooms, and that is on the south end of that residence. The southeast bedroom would be Tyler's, and then the southwest would be the spare bedroom. Again, if you go back to the stairs and you make a right-hand turn, that is where you're now on the north end of that residence, and that is now Twig's bedroom.
And where were these items here in 23 found?
These were found on the southwest, or in the southwest bedroom, the one right next to Tyler's bedroom.
And you said on top of a safe.
Yes.
All right. Will you describe what we're looking at in Exhibit 23?
Exhibit 23 are the 5 cartridge casings we found on top of the safe, all with .30-06 Springfield caliber, and one of them had an engraving that said "test shot" on it.
You've talked about Springfield, Remington. Are these 30-06s? Are they the same type of round as was found in the gun?
Yes.
All right. Did you find any 30-06 weapons in that house?
No, we did not.
All right. Did you search the closet on the first floor?
Yes, I did.
What did you find in the closet?
In the closet, we found on the ground some shooting targets with perforations in it, as well as on the shelf, we found a Dremel tool with bits container.
All right, a Dremel tool with bits. What is a Dremel tool?
It's basically like a handheld device where you can make etchings or engravings on things.
What are bits?
Bits would be I guess like a sharp edge or something that that would actually cause the etchings that you would put into the tool.
Is this kind of like a drill bit?
Yes.
And what did you do with the Dremel and the bits?
We photographed them in place, took additional pictures, packaged them, then sent them for testing to the ATF.
All right, you also mentioned targets.
And there's the Dremel device, or a device like that with the bits. And this is what was used to engrave the bullets, which sounds like it's right out of a movie, to be honest.
All right, note the standing objection, and those objections are overruled.
And
Stacy,
Excuse me, sorry.
oh, well, did you want to, in regards to publication?
Yes, I'm so used to admission before publishing. I would move to publish those at all 3 levels.
Any further comment, Mr. Brooks?
No further objections.
Again, all right, noting the standing objections, those are overruled. Stacy Exhibit 25 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
Will you describe what we're looking at here?
Yeah, so these were shooting targets we found in the closet, and each of them have have perforations in them.
You say perforations, what do you mean?
Holes in them.
Those holes consistent with?
Objection, foundation on this opinion.
Mr. McBride, do you want to weigh in upon that objection?
No, I'll submit it. I'll lay foundation if the objection is sustained.
I'll sustain the objection.
All right, holes. Have you ever shot a gun before?
Yes, I have.
When you hit a target, what happens to the target when it's hit with a bullet?
The hit with a bullet, there's holes in it, what we call perforations, because there's a entrance as well as an exit.
Looking at State's Exhibit 25, I'm going to ask the question that was objected to. You said there's perforations in those. Are those consistent with bullet holes?
Yes.
And I would ask you to describe where those perforations are there's 3 targets here, right?
Yes.
Let's look at the far right target first. Where are the perforations in relation to the bullseye?
They're all probably within the 7, 6, and 8 ring.
Is there a perforation up at the upper left-hand corner of that rightmost target?
Yes, there is.
Do any of those hit the bullseye?
No.
Okay, looking at the center target, will you describe where the perforations are in relation to the bullseye there?
It is closer, but still not it. Most of them are to the left of the bullseye and rings, I'd say 9 and 8.
All right, and then the leftmost target, will you describe where the perforations are there?
The perforations are actually closer to the bullseye as well, actually one being in it.
All right, you described also collecting a burnt note. We can take down 25. Thank you. Will you describe where that note was found and what it looked like to you?
The burnt note was found in the trash can located in the kitchen. The way it looked like to me, it looked like, say you're at like a campfire and someone burns paper.
What was done with that?
That was also collected and that was sent to the FBI for analysis.
Was it photographed?
Yes, it was.
And have you reviewed State's Exhibit 24?
Yes,
Is that a photograph of the note?
yes.
I move the omission of Plaintiff's Exhibit 24.
Mr. Garrett?
No further objections.
All right, and to publication?
I move to publish at all 3 levels.
All right, I'm going to note the standing objection by defense, overrule those objections. And State's Exhibit 24 is admitted into evidence and may be published in the courtroom and may be captured by the media camera.
Do you see here on the screen Plaintiff's Exhibit 24?
Yes, I do.
It looks like as to the evidence tag, it's actually upside down. Is that right?
Yes.
Does it look like there's any writings on that note, on that burnt paper?
Yes.
Will you point that out for the judge where the writing is?
Yep.
And describe what you're pointing at, kind of the general location on the image.
Yeah. So the part that I'm pointing out is the paper that you can still see the lines in them, and as well as some handwriting as well to the edge, the left edge of that piece of paper.
All right. Have you also observed the image of a note that was recovered from Lance Twiggs' phone?
Yes.
And I'd like to show you side by side Exhibit 24. And there on the left, you see there on the left, we see Exhibit 24. Do you see that?
Yes, I do.
And on the right, you see, on the right is 24. On the left, it's 16.
Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?
Let's take that down.
All right.
Exhibit 24. Thank you, Your Honor. Exhibit 16.3. I would move to publish Exhibit 16.3 and 24 side by side. I think they're currently on the council monitors.
So 16.3 has already been admitted.
And I don't remember the court's order if this was to be captured by electronic media or not.
No, it was not.
Okay.
Does that comport with defense's memory as well?
It does.
All right. So 16.3 was published to the courtroom, but not to be captured by the media. So
Very well.
And what is your request?
To comply with the court's order.
All right. So 16.3 and Exhibit 24 may be published side by side only to the courtroom itself, but not on to be captured by the camera.
Producer Steve stepping in. It looks like they muted the conversation to the media as well. So whatever they're discussing now, they don't want the public to know. So the only way you would know this conversation is if you were in the courtroom. Also, David's computer crashed while all that happened. So we're just dealing with it in real time. But this is pretty standard for courtroom stuff. They're going to talking about it as us normal folk would be, but like it's very much process based as to what is and isn't allowed to be seen to the public. And Angelica brings up a good point. If you can read lips, you actually do know what's happening. But even still, you would only know what Judge Graff is saying. Graff Jr., I think he would just be Judge Graff. We're going to find out. So David's back with us to explain. There was talk over an exhibit as to whether or not the exhibit should or shouldn't be shared with the media. And then they kept discussing it, and then they eventually muted the audio to the media.
Okay.
To further discuss it.
Thank you. We don't know what the exhibit was?
I could guess because we saw the burn paper, the burn thing. So whatever came
so it
after
could've
that,
been
they described
whatever that
it.
was. Well, we'll talk generally about like what's happening in this
Acknowledging that the
preliminary hearing.
magistrate can weigh the
And
evidence.
with this witness on the
weighing
stand,
in
Sergeant
on this
Jennifer
evidence solely
Falmina, they're
admitting
using
it.
her to get evidence admitted into court. And there's a certain way, there's a procedure you have to do that, where you have to lay the proper foundation. And then there has to be somebody with knowledge who can authenticate it. And that is what is transpiring here. So now that they're back speaking, the audio is back. Let's return to it.
Doesn't accept that will be a determination made when determining probable cause.
Thank you. Do you see any consistencies that you're able to?
Okay.
So funny. I think while we were talking, he might have explained to the media why the media can't hear whatever's happening here, which is why we're just seeing him and then not. And Angelica, no, just autistic, film degree.
Angelica just asked if you're a lawyer, Steve. She
Yes.
says that you sound like one.
I take the correct amount of honor with sounding like one. No, I just watch a lot of stuff on YouTube.
Which is good. You're my unofficial paralegal, associate counsel here. But there's been a lot of evidence that they're putting forth in this case that we're able to see, that has been published and that the public is allowed to see. So much so that I'm not even sure what the defense argument is going to be here. Oh, wait, we're back.
The defendant's car.
Yes,
Where did you collect that from?
that was collected at the Robinsons' parents' home.
And will you describe that vehicle?
Yep, that vehicle is a gray colored Dodge Challenger.
All right. You've mentioned that you sent several items to the ATF and the FBI for testing. And did you receive reports back from both of those entities with results of their testing?
Yes, I did.
I'd like to show you on the witness's screen only right now, or counsel's screens, Exhibit 30.
All right, while you're doing that, Mr. McBride, and also, could we go ahead and take down State's Exhibit 35? I know it's just in the background, but just to be consistent on displaying of exhibits. All right, thank you. You may proceed.
Plaintiff's Exhibit 30. Do you know what this is?
Yes, this is the ATF report that I received regarding the DNA testing on the gun and cartridge casings. Or sorry, correction, cartridge case and cartridges.
Thank you. And is this in the same condition as it was when you received it?
Yes.
Your Honor, I'd move the admission of Exhibit 30.
Mr.
No
Ver-
no further objections, Your Honor.
All right, I note the standing objections, and as to publication, Mr. McBride.
Yes, Your Honor. This exhibit deals with DNA testing on the rifle and the cartridges. We would move to have it published at all 3 levels.
All right, so noting the standing objection by defense, I'm going to overrule that objection pursuant to Utah Rule of Evidence 1102. State's exhibits, and this is 30?
30.
State's Exhibit 30 is admitted into evidence and may be published on screen in the courtroom and for the media camera.
Okay, I can't tell if they've paused the video or they're redacting it or what's happening now. Steve, are you paused on your end? Oh, wait, here we go.
I want to ask you a little bit about the format because it may be helpful to understand here. But on page 1 under the exhibits, we have here a list of items that were sent in for testing and comparison. Is that right?
Yes.
And throughout the report refers to the items compared by the lab number. Is that right?
Yes.
So if we can scroll down just to the bottom of this first page, and here in the DNA analysis section, again, we see that the report or the author refers to the items by their exhibits numbers, right?
Yes.
Okay. And if we can go to page 2, and same question here, the exhibit number on the left, if we want to know what exhibit number that is, we have to refer back to page 1 for the description, right?
Yes.
Okay. And let's keep going to page 3. If we can just scroll through page 3, 4, and land on page 5. Actually, pause right there if you will. This is page 4. There's a description section here as well. And that description talks about where the swabbing that's used to compare what was swabbed for the comparison. Is that right?
Yes.
Okay, let's go to page 5. So as we look at this first paragraph here under statistical analysis, let's see if you have this notated or no. Exhibits 1.1 and 1.4. Do you know what that is referring to?
Yeah, they're referring to 1.1 is swabs of the stock and grips of the rifle, and then 1.4 is swabs of the bolt of the rifle with possible ridge detail and or smudging.
Okay. Will you read paragraph D?
Yes. The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson, Exhibit 7.1, as a contributor to the major components and 3 unrelated unknown individuals than if they originated from 4 unrelated unknown individuals.
And again, that's swabs of the grips and the bolt, stock and grips and bolt. Is that right?
Yes.
Okay. Number 2, calculation number 2. Where is this swab taken from?
Exhibit 1.2 would be swabs of the butt plate of the rifle.
And will you read paragraph D here?
The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 4 unrelated unknown individuals than if it originated from 5 unrelated unknown individuals.
Looking at calculation number 3, exhibit 1.3, what areas were swabbed for this comparison?
1.3 is swabs of the trigger and trigger guard of the rifle with possible ridge detail and or smudging.
We read paragraph D.
The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
If we can go to page 6. Calculation number 4, exhibits 1.5 and 5.1. What are those?
1.5 are swabs of the forend of the rifle, and 5.1 is swabs of one 30-06 cartridge
And again, that cartridge came from where?
from the firearm.
Will you read paragraph D?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
All right, let's look at calculation number 5, 1.6 and 3.1. What are those?
1.6 is swabs of the barrel of the rifle with possible ridge, detail, and or smudging, and 3.1 is swabs of one 30-06 cartridge
And that 30-06 cartridge came from where?
from the firearm.
Will you read paragraph D?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as a contributor to the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
Okay, statistical analysis calculation number 6, exhibit 1.9. Where is that from?
1.9 is the swabs of possible ridge, detail, and or smudging on the optical accessory of the rifle.
Is that a scope?
Yes.
Will you read paragraph D?
The DNA profile is 6.28 billion times more likely if it originated from Tyler Robinson as a contributor to the major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
Okay. On number 7, I'm not going to read that. I think we've gone through this enough. That's the last one in this report. Is that correct?
Yes.
All right. We can go to exhibit 32. 31 was previously received. And just display this on the screen of the witness, please. I think it might be display. It might display on the gallery video. Okay. All right. Thank you. Can you see exhibit 32 on your screen, Agent Thomas?
Yes.
What is this?
This is an ATF report that I received in relation to the gun as well as cartridge case and cartridges.
And is this report in the same condition as it was when you received it?
Yes.
I move the admission of State's Exhibit 32.
So question for you, was this the report that was previously disclosed in one of the early motions?
Yes.
All right. All right. To Mr. Burtz.
No further objections, Your Honor.
And for publication level?
All 3 levels.
All right. As it relates to State's Exhibit 32, is accepted into evidence, may be published in the gallery as well as electronic. The media camera can capture it. And I note that this has been previously disclosed publicly from an earlier filing, I believe from either late last year or early this year. So for those reasons, it's accepted into evidence and may be published at all levels.
Your Honor, it's 2:30. I probably have 10 more minutes. Would you like to take a recess now or after I finish?
Let's just do the 10 minutes.
All right. Exhibit 32 is in front of you. And what was being analyzed in this test?
What was being analyzed would have been the cartridge case as well as the bullet fragment and the lead fragments that were recovered from Mr. Kirk at autopsy.
Right. Same question on structure of the exhibit. The lab numbers and agency numbers are listed here on the first page, right?
Yes,
And if you want to know what the report is talking about, you have to refer back to there, right?
yes.
All right, I want to have you read, if you can scroll down to the bottom of page 1. Thank you. I would ask you to read the second line under results of examination.
Yes. The Exhibit 1 rifle was test fired and found to be in operable condition. The test fires were designated as Exhibit 1.11.
And again, Exhibit 1 rifle is what?
Is the one that we found on campus.
Okay. Exhibit 2, if you'll look at the next, skip the next line and then go to the Exhibit 2 cartridge case, will you read that sentence?
Yes. The Exhibit 2 cartridge case was identified as having been fired in the Exhibit 1 rifle.
Okay, now I want to jump back up to the top where it lists the exhibits. 2 through 5, will you explain what those are and where they came from?
Yes. That would be the items we found in the gun on scene. And this was the gun that was found in the wooded area.
And so the cartridge case is the round that had been, is the case that had been fired.
Yes.
Okay, so that's number 2. All right. I can't remember. Did we already read that line? Exhibit 2 cartridge case?
Yes.
Okay, thank you. Will you also look at or read the last paragraph on this page?
Yes. The Exhibit 2 cartridge case and Exhibit 3 through 5 cartridges were examined for the presence of comparable tool marks. Tool marks were located on the exterior of the Exhibit 2 cartridge case and Exhibit 3 cartridges, in parentheses, scribe marks, that are consistent with being produced by engravings and or rotary cutting tips commonly found.
Let's scroll down, please, Kimberly.
Installed in handheld rotary tools, such as a Dremel tool. These tool marks contain marks of value for comparison if a suspect tool is located.
Okay, I'd ask to scroll back up to show the exhibit list. Number 6, what is Exhibit 6?
Exhibit 6 is the bullet fragment, the bullet jacket fragment, as well as some other fragments that were recovered from Mr. Kirk at the time of autopsy.
Thank you. Going back to page 2, will you read the first full paragraph there, beginning with Exhibit 6?
Yes. Exhibit 6 consists of one 30 caliber class deformed damaged bullet jacket fragment and 4 lead fragments.
Will you read the next paragraph as well?
The Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1 rifle based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The results of the comparison was inconclusive.
And if you'll look at the line starting with the Exhibit 6B through 6E, will you read that sentence as well?
The Exhibit 6B through 6E lead fragments are not suitable for microscopic comparison.
Thank you. We can take Exhibit 32 down. Exhibit 33, if we can show that just to the witness, please. You recognize Exhibit 33?
Yes.
What is that?
This is an ATF biology report on the Dremel tool as well as the cartridge cases that were found on top of the safe in Tyler's home.
Did you receive this from the ATF in response to your request for testing?
Yes, I did.
I move the admission of State's Exhibit 33.
No further objections, Your Honor.
Thank you, Mr. Burtz. Noting the standing objections by defense and level of publication, Mr.
All three.
McBride.
all three levels.
Court overrules the standing objections and states Exhibit 33 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
What was being tested here?
The Dremel tool, the bits container, as well as the cartridges and cartridge casings we found in Tyler's home.
And up in the top right, it says forensic biology. Is this DNA testing?
Yes, it is.
Okay, format of this is the same as the other report that we already looked at, right?
Yes.
Let's jump to page 4. Calculation number 1. It mentions here Exhibit 15.1. Do you know where that swab is from?
Yep. It is swabs of the buttons of the Dremel tool.
And will you read paragraph D?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a contributor to the major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
We also read paragraph E.
The probability of an unrelated individual in the population who has not contributed DNA to this sample yielding this level of support is less than 1 in 1 trillion.
Thank you. I'm not going to ask you to read those paragraphs for the rest of the statistical calculations, but I will ask you to go through and identify where the swabbing came from. Exhibit 15.3, which is calculation number 2, where's that swab from?
As swabs of the cord of the Dremel tool,
Exhibit 15.5,
that would be swabs of the longest metal bit of the tool.
going on to page 5. Calculation number 4, exhibit 15.6,
15.6 is swabs of the shortest metal bit.
and calculation number 5, 18.1.
This is swabs of 1 etched 30-06 cartridge case
What is that? Where did that come from?
that come from on top of the safe.
Okay. Is that the one that had the etching test shot?
Yes.
Will you read the paragraph D as it relates to the test shot swab?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
Thank you. We can take exhibit 33 down. The final report is 34, if we can publish that just to the witness. What is State's Exhibit 34?
This is an ATF report I received that was comparing tool marks.
And is this, I move the admission of Plaintiff's Exhibit 34 and publication at all 3 levels.
Mr. Burt.
No further objections.
All right. And, all right, so State's Exhibit 34 is admitted. The objections, the standing objections by defense are overruled. They may be published in the courtroom and captured by the media camera.
Okay, looking at the exhibits, might have to go back and forth here, but let's go to page 2. And will you read the paragraph that starts with Exhibit 18 consists?
Yes. Exhibit 18 consists of 5 30-06 Springfield caliber fired cartridge cases designated Exhibits 18A through 18E and 15 45 auto caliber unfired cartridges designated Exhibits 18F through 18T.
Okay. 18A, do you know what 18A is?
Yes, this would have been the 30-06 cartridge case with the engravings test shot on it.
Okay. Will you read the paragraph beginning with the Exhibit 18A?
The Exhibit 18A cartridge case was examined for the presence of comparable tool marks. Numerous sets of tool marks were located on the exterior of the Exhibit 18A cartridge case that are consistent with being produced by engravings and or rotary cutting tips commonly found installed in handheld rotary tools such as a Dremel tool. These two marks contain marks of value for comparison.
Okay. The next paragraph I asked you to read is the one that starts with Exhibit 16. But first I want to ask you, do you know what Exhibit 16 is?
I do not, off the top of my head.
Okay. 18, it also says Exhibit 18A through 18E. Do you know what those are?
18A through 18E would be the cartridge cases that were found on top of the safe.
If you'll read paragraph, or that paragraph,
Which one again? Sorry.
the one starting in Exhibit 16 and.
Yes, the Exhibit 16 and Exhibit 18A through 18E cartridge cases were identified as having been fired in the Exhibit 1 rifle.
Okay, let's now jump to the paragraph beginning the test tool marks. Kimberly, if you could scroll down. Will you please, well, first off, 15A and 15B, do you know what those are?
Yes, those would be the longest metal bit and then the shortest metal bit.
Okay, if you would read, okay, and then also Exhibits 2, the Exhibit 2 cartridge case, what is that?
This would have been the cartridge case that was found in the gun.
And Exhibits 3, 4, and 5 cartridges?
They were the ones also found in the gun.
And Exhibit 18A?
Is the one that was found on the safe.
Okay, if you'll read the first bullet point there, the Exhibit 15A.
Yes. The Exhibit 15A engraving cutter was identified as having made tool marks located on the Exhibit 2 cartridge case, Exhibit 3 through 5 cartridges, and Exhibit 18A cartridge case.
And will you, okay. We can go ahead and take that down.
We're getting a clear look at the defendant right there, Tyler Robinson, who's been present for all of this. That's his defense team with him. Not certain if they've muted the audio or what's happening right now. Sounds like they have.
Your Honor, I want to, before I ask to enter my final line of questioning, I would like to show the witness Exhibit 12.1. And this is the video, the UVU surveillance video. Let's see, I think it's 12.4 was the surveillance video actually that was approved for publication.
That's correct. That's the
And-
unmarked, non-zoomed version, correct?
Is that correct? Yes.
Yes, that's the one that, yes.
And just for now, let's do this on the witness's screen. .4, and I'll ask you to jump to the 804 mark. Okay. I'd move to publish. We intend to play about 10 seconds of this video. I'd move to publish that at all 3 levels.
Mr. Burt?
I'm not sure what the relevance is at this point, so it's hard to object or not. I would ask for a proffer as to what it's showing.
Prof.
It's not apparent from the exhibit.
Understood. Proffer is, there's been testimony about about prints being found on the glass window of this building. This exhibit demonstrates the suspect's behavior in that area.
All right. Anything further?
With that, I don't have any further objections.
All right. So it may be published. This is already admitted, and it may be published at all levels.
Okay, before you pause, before you hit play here, Sergeant Falmuina, do you see what's on the screen in front of you?
Yes, I do.
Can you see the suspect in this image?
Yes.
Will you describe where that suspect is?
He's on the rooftop, let's say on the gravel part, and this would have been close to the northeast side of that building.
Timestamp is 12:23:47 p.m. Is that right?
Yes.
And that portion of the image that we see there, the video, is the top portion of the image slightly to the left of center. Is that right?
Yes.
Okay, we're at 8:01. Kimberly, will you please hit play there? Let's go ahead and pause it. Pausing it at 8:20. Were you able to determine if the suspect touched the glass when he dropped from the roof?
Not at the time when we first saw the video, no.
Okay. Were you later able to make any determination on that?
Yes, because the video we had was pretty grainy at the time on at the command post, and it wasn't until we're actually able to get the footage directly from UVU.
And when you actually got that footage, could you zoom in and get a better picture?
Yes.
And were you able to determine at that time whether the suspect touched the window?
Yes.
What was your determination?
We determined that he was not, or he did not touch it.
Thank you. Nothing else.
All right. Let's go to a break. To defense, I realize that you began talking about your concerns. You have a witness that needs to leave today. 10, 15 minutes, what's your request? I want to maximize your ability to have time with your witnesses as well as cross if you choose to.
Just 10 minutes would be fine.
All right, let's break for 10 minutes and then come back and cross-examination. Court is in recess.
All right. So you see the seal of the state of Utah there, and they're going to take a 10-minute break. We'll stand by and wait, but there was a lot that was covered, and I'm glad we cleared something up there at the end, because one of the things that Sergeant Jennifer Falmina, I believe her last name is, one of the things she first testified to was that there were fingerprints recovered on the window there where you saw the individual, the suspect, drop down, and the fingerprints recovered were not those of Tyler Robinson. They did not match. And so initially upon hearing this, I said, well, that's the first piece of evidence that is in the defense's favor. However, now the prosecution came back and they cleared it up, and they asked her, in viewing the video, did the suspect touch the window upon dropping down? And Sergeant Falmina said no, that the suspect did not touch the window. So it still could be Tyler Robinson, but that explains why there would be fingerprints from somebody else other than Tyler Robinson. And so they're kind of immaterial then, because the individual suspect who dropped down did not touch the window. It would be different if she testified that the suspect did touch the window, because then now that would show that this is presumably a different suspect if there were fingerprints recovered, not Tyler Robinson's, and the suspect touched the window. However, again, just to be clear, the suspect did not touch the window. So whatever fingerprints they're immaterial here. So still everything else points to Tyler Robinson. And they spent a good bit of time talking about the bullets, the casing, the cartridges and the casings, and how Tyler Robinson, well, he had access to a Dremel engraving device, and whoever the suspect, well, apparently they were his because they were recovered from his home. Whether or not they were used in this crime, we don't know yet. However, they have to have the evidence linking that. However, it appears Tyler Robinson did indeed engrave his bullets and cartridges. And earlier, that wasn't on this stream, but Lance Twiggs, they played his police interview and the first time that he was interviewed, they played this in open court. And this was challenged on both sides, or I'm sorry, challenged by the defense because Lance Twiggs would not be there in person to give his testimony. However, this was let in under, I want to get the rule right here. It's Utah hearsay exception. What did they say? It was 1102. And the reason is this is allowed because this is a preliminary hearing. So this is not a trial. This is basically the prosecution putting on all their evidence to show that they have enough evidence to make Tyler Robinson stand trial. And at this point, it seems overwhelming. They've got a mountain of evidence, not to mention Tyler Robinson turned himself in. So if you look at this, Tyler Robinson turned himself in. He wrote a confession or some kind of a letter beforehand, which shows evidence of planning. His roommate, he tells his roommate where to go to find it. His roommate was also his romantic partner. So Lance Twiggs is Tyler Robinson's roommate and romantic partner here. Oh, here we go. Yes, and we should say this. So I'm not sure if now, presently, Lance Twiggs wants to be known as Luna Twiggs. But let's see, what do we see here? Tony Graff has referred to Twiggs by her birth name and with she, her pronouns. So the birth name, I believe, is Lance Twiggs, but she, her pronouns. I will do my best to try to keep this straight. So the NPR reported last month, the defense records indicate Twiggs' name at birth was Lance, but her chosen name is Luna. She uses she, her.
I know an Otunga computer break when I see one. We're going to get him back in a second. I was just bringing that up for clarity's sake, just because in later proceedings we may hear people refer to Luna, and then we might not be sure who is what. That's all I like. And in general, just it's polite. If somebody tells you what their name is, that's their name. But last name Twiggs is pretty unique. Mediaite. I'm trying to find the exact motion he was referring to. Let me interact a little. Angelica, I also wonder what the defense is going to present here. My understanding that all I've seen is just this whatchamacallit? Just this one testimony. But based on this one testimony, it feels to me that the defense is mounting a mistrial or an appeal by how much they're objecting. That like everything that somebody submits, they're like, I have no further objections, or I have an objection, or I have an objection that you're going to show this on the feed, or I feel like they're trying to build a possible defense, a credible defense in this case, but more likely a mistrial at the end of this case or an appeal later is my guess. I'd like to actually hear what David thinks when he gets back. He said Rocktopus again. For those uninitiated, because it didn't happen on the Lawyer channel. Rocktopus, which is a thing you print in 3D printing, is also an example to us of Dwayne "The Rock" Johnson being involved in everything somehow. And he is who shuts off your computer when your computer goes bad. But I'm also with you, Angelica, that I think this is about minimizing. David's back.
Sorry, I missed that question from Angelica. What did we have?
She's specifically asking if it's about guilt anymore, if this is about an official trial, or does the verdict seem foregone?
Right. So this is not about guilt or innocence here. This is about establishing if there's enough evidence to bring Tyler Robinson to trial. This is essentially an alternative to a grand jury proceeding, but this is public. And what it does is it establishes a record and establishes certain testimony that people give and locks them in. For example, Sergeant Jennifer Falmina, her testimony here is under oath. So presumably, if and likely when this goes to trial, they will be able to refer back to her testimony. She'll have to say things consistent with this. However, there is, like we were discussing before, there is a lot of evidence against Tyler Robinson, a lot. And that testimony of Lance or Luna Twiggs, that she provided, or the interview they played earlier, details a confession and a long text exchange with Tyler Robinson where Lance asked if Tyler was the shooter, and Tyler said yes. So admitted that he had done it, talks about his escape and that he was waiting. He had to drop the rifle, his grandfather's gun. He dropped it somewhere at the drop point, he called it, which was the wooded area that we saw here where it was recovered. And he was waiting because he wanted to go back and get it. And he had stated something to the effect of that if he was able to retrieve his rifle, he would have left no trace of any evidence behind. So he planned this out. And it's interesting because from his words, it sounds like it was well planned out. But from my perspective as a lawyer, it was not well planned out at all. And here's his path here. So there was all kind of video footage of him as well, where he got up early and went to the scene, scoped it out, then left, and then later came back, had changed his clothes. What was seen walking with what appeared to be a limp, as that he didn't have before, which is assumed that the rifle was in, I believe it's his right pant leg. So there's all of this information, all of this video footage, which really clearly shows his car. I mean, how many different pieces of evidence directly tie him to this? Not to mention that when the gun or the rifle was retrieved, it was in a towel that had been presumably from the apartment that Tyler Robinson shared with Lance Twiggs, and it had both of their DNA on the towel. So that towel did not just have Tyler Robinson's DNA, but also had Lance Twiggs' DNA. I find this extremely strong because, okay, if you take into account the defense theories from the internet, not the defense, because the defense has not put forth a theory of their case or anything, but the theories from the internet that Tyler Robinson was framed. Okay, there, you might find his DNA on it, but the fact that you have his roommates or his romantic interest DNA on it as well, I mean, that I don't know about that. What are the odds of that? That seems pretty difficult to do in terms of framing somebody. That seems like very clearly that towel was taken from his apartment. Rifle was wrapped in it. And you have all of these statements, his admission, and then finally, he turned himself in. I mean, Tyler Robinson turned himself in the next day. He showed up to the police department, turned himself in. So at this point, I mean, I don't know if there's going to be a trial, because I think there's so much evidence. The fact that he turned himself in, I think there could be a plea deal potentially, which would make sense in this case. There's just so much evidence. I mean, I don't know what an alternative theory would be. And to be perfectly honest, I don't even know what his defense would be if I was his defense team or his defense counsel. Yes, Steve.
To rebut the one thing, let's say a high profile person is murdered today.
Okay.
And then by tomorrow, stuff surfaces that they think it's you. Would you run or would you turn yourself in? And let's assume you're innocent, because the assumption has to be innocence. If your face and a picture of you where you were, and I'm saying that one piece of evidence, that him turning himself in, I don't know if that piece of evidence is a smoking gun, as they say. Everything else is,
Okay.
but I think him turning himself in because he's the subject of a manhunt, I don't think is guilt in and of itself. Because if
Okay.
I was the subject of a manhunt, I would rather turn myself into the police for my safety.
I agree with that. I'll add to that though. I'm not certain if he had been identified at that point. I don't believe he was. They had images that, weren't the most clear. It's not like you could just see those images and, well, maybe some people, if they knew him well. But his name wasn't released, or I don't even believe his identity was known. They had the DNA because the only reason they were even able to match the DNA is I believe they had to take his DNA sample and compare it with that. So it's not like they found the gun and then swabbed it and you put it into a computer and it pops up the name Tyler Robinson. We haven't advanced that far yet with technology, but maybe one day that'll be the subject of an interesting movie. However, I do see your point though, is if things were pointing towards him instead of running, he could turn himself in if he truly had nothing to hide. However, I'll say what's problematic about that is with it lines up with the text messages to Lance where he admits to the crime and then also says he intends to go and turn himself in, and then he does. So all of that lines up. Now, I mean, it could be argued that we don't know who was sending the text messages from his phone. It could be an elaborate scheme, an elaborate
Court is
frame
back in
job.
session.
We're back
Noting
in
the
session.
presence of all
Yeah.
parties, we just ended with a direct examination of the sergeant. Turning to defense, Mr. Burt, the
Thank you.
witness.
Good afternoon.
Good afternoon.
Your role in the case was kind of as the traffic manager of the whole operation, right?
That's a good way to put it. Yeah.
And we're talking about multiple agencies besides the SBI, correct?
Yes.
Your agency, if I'm correct, wrote a massive report, 229 pages long.
Yes.
You've read that. You're familiar with it.
With most of them, yes.
Okay. And it's a compilation, right? You authored some reports, but a lot of other people wrote reports about aspects of the investigation.
Yes.
And as those reports were getting done, you would kind of read them and decide what needed to get done further?
Yes.
Was that one of the roles that you
Yeah.
performed in this case?
Yeah, yes, as well as consulting with the case agents.
Okay. Now, if my count is correct, 9 of those reports in that larger body of reports was written by you, correct?
Yes.
Did I miss any? Does
There are
that
more.
sound about right?
Yeah.
Okay. I want to ask you about a couple of those reports. The first report was a report that you wrote on September 22nd that documented the overview of the crime scenes, correct?
Yes.
And there were various crime scenes that you've described on direct examination, correct?
Yes.
One of them was the Fulton Library.
Yes.
Tell us why that was a potential crime scene.
Yeah, of course. When officers were canvassing the scene, they were also trying to see, right, the route of the shooter as well as just trying to find the shooter. And they determined that the Fulton Library stood out because there were unattended items there at the bus stops that were away from the courtyard area. And so to them, they thought it was suspicious.
And were certain items seized from, and what were they?
Yes, you had a backpack, a jacket, as well as some gloves. And there may have been some other things. I just don't recall them right now.
And do you recall what the item numbers were of those seizures? Was it 9? Does that ring a bell?
I don't remember.
Whatever was seized was sent to the FBI lab for processing.
Yes.
And along with some information that the suspect may have shed some of these items as he fled, correct?
Yes.
Was a decision at some time made, and you were requesting that both DNA and other type of analysis get done?
Yes.
At some point, did you decide to pull a plug on that?
At the time when it was already sent, we didn't have more information as far as whether or not the evidence that were collected there were probative.
but eventually you communicated to the lab that those items were not in fact connected with the case and there was no need to do further testing.
I don't remember communicating that.
Okay. If that's in the notes of the FBI or the ATF, would that be inconsistent with what you know?
No.
Okay, I mention it because some of the reports, the lab reports, have those items listed.
Okay.
I just want to be clear that those items eventually you determined were not related to this case. Would that be fair?
Yeah, that would be fair.
Okay. The second report, at least as far as I can see, that you wrote was on September 24th, and it had to do with looks like a request for a search of firearms. Do you recall that?
Could you elaborate for me on the firearms?
This document documents that NIBIN request for firearms.
Yes, so that was the request to conduct. What that stands for, the NIBIN, is the National Integrated Ballistics Information Network. It is run by the ATF, and that is where we test or we input test fires or cartridge casings, the head stamps and whatnot, into a machine that is then run through the ATF to see if there's any other cartridge casings that match.
And nothing of value came from that part of your investigation, correct?
Correct.
Now going back for a minute to the crime scenes, you talked about the wooded area and you used the phrase, "we seized the towel." Who is we? Who are you referring to when you say "we seized the towel"?
We would be SBI as well as FBI. So that would be myself as well as FBI Evidence Response Team Lead, Michelle Kamak, or Special Agent Michelle Kamak.
So you both reached into the bushes and you both grabbed it and pulled it out?
She did, but I was there with her and we were communicating that entire time.
Okay, so when you say "we seized the towel," what you really mean is she seized the towel and you observed her seize it.
Yes.
And when she sees a towel, can you describe a little bit more detail of how that process took place?
As far as when it was found or when she removed it?
Yeah, the photographs you showed us, were those the best photos you've got of that process?
That was taken by the FBI, so that's all we got.
That's all you got. And nobody was videoing the discovery and recovery of that evidence?
I believe one of the officers on scene actually had his body camera on.
And have you seen that?
I have not.
Do you know if there's any documentation of the exact process by which that towel got removed from the rifle and then I guess put back on the rifle, right?
No, it was not.
It was not put back on?
No.
Didn't one of the photos show the rifle in the box with a towel over it?
Yes, it
So-
wasn't over. It was still wrapped around the gun.
Okay, but as I understood your testimony, the towel was seized by the FBI agent and then somebody must have reached in and got the gun out, right?
No, I'll clarify for you. So
Sure.
the entire time when we retrieved it, the gun was wrapped in the towel. So when Special Agent Kamak reached in, she grabbed not only the towel, but also the gun. And it remained, and the towel and the gun remained basically intact, lack of a better word, and then was placed onto the cardboard box, which is one of the photos that was shown earlier. Once we documented that, and then the towel was removed from the gun.
You also mentioned this to the other crime scenes that we processed it, but was your role in terms of your actual participation limited to the wooded area? Or were you involved in actually seizing evidence at the other locations, like the roof?
Yeah, I was involved in coordinating all that and then determining from there where the evidence would go.
Involved in, is that the same thing as actually being on the roof and seizing the items? Or are we talking about something else?
Talking about something else.
And what is that something
So
else?
after the teams would have packaged all the items, sealed them properly, created an evidence log, they will then bring it back to the command post. And from there, we would compile everything. And then there was a discussion that was had as to who would take custody.
Fair to say that you did not observe yourself the seizure of the screwdriver from the roof.
Correct.
And who were the people who were actually conducting that part of the crime scene processing?
That would have been our state crime lab, those two people are part of our state crime lab's crime scene response team.
When did you review the video of the suspect running toward the area from which he jumped off?
That would have been, I don't know the exact time, but it would have been the day on September 10th.
You saw that on September 10th.
Yes.
And when were the windows processed for the latent fingerprints?
The windows were processed on September 11th, the next day.
And was the reason that those latent lists were taken was because you wanted to rule out whether the suspect had touched that window?
Yes.
That's what the notes say, right?
Yes.
You were not present when that scene was processed either, correct?
Not the entire time, no.
Okay. Now, the other reports that I have that you did, and correct me if I'm wrong, is one report dated September 24th, documenting the forensic analysis as of September 24th, summarizing what you were hearing back from the ATF and the FBI.
Yes.
Okay. And then the fifth report was again about the crime scene progress of the forensic testing, right?
Yes.
Right. And then you have a report here which documents a firearm trace and a firearm seized at River Street.
Yes.
Nothing of value came of that, correct?
Correct.
You have a report that has to do with the latent print report from your people, SBI.
Yes, or it's not SBI, it's actually the state crime lab, but yes, same department.
Same department. Just detailing the results of that examination, which the stipulation addressed.
Yes.
Right? You have a report documenting the transfer of evidence from the FBI to your department.
Yes.
And then the last one that I have that you personally wrote has to do with again, summarizing forensic reports.
Yes.
Okay. The larger 229-page report indicates that there was some investigation done by your agency that involved interviewing associates of Mr. Robinson to see if you could develop some profile of him having animosity toward Mr. Kirk, correct?
I'm not familiar with that.
So you weren't involved in that at all?
No.
Some of the documents in that large report indicates that your agency has also, up to the present time, been monitoring Mr. Robinson's mail and communications at the jail. Correct?
Correct?
And have you kept abreast of that investigation?
No.
Do you know whether anything of value has been developed as a result of that?
No.
That's all I have. Thank you.
Thank you, Mr. Burt. Redirect? All right, may this witness be excused?
Yeah, there's no point for redirect there. The defense counsel did his best, but I'm not sure what he really accomplished there.
Yeah, let's make sure. Thank you, Mr. Gernander. Appreciate creating a good record.
Judge, if I could just confirm with the court that all of the exhibits we have offered have been admitted into evidence.
All right, so here's what I have, and my court clerk will certainly correct me if I'm wrong. I have State's Exhibit 1, 2, 3, 3.1, 3.2, 4, 5, 5.16, 6.17, 7.18, 8.19, 10, 10.1, 10.2, 10.3, 11, 12.1, 12.2, 12.3, and I believe 12.4, 13, 14, 15, 16, 16.1, 16.2, 16.3, 16.4, 17 and 18 are blank, so no.
That is
19
correct.
All right.
We're not offering 17 and 18.
All right. 19, 20, 21, 22, 23, 24, 25. The following are blank: 26, 27, 28, 29.
That's accurate. We're not offering on those numbers.
I have 30, 31, 32, 33, 34, and 35, which have been admitted into evidence.
That is all that I have record of.
All right,
Go
does
ahead.
that comport? I mean, we certainly can. Yes, would you like to put on the record what were published and what were not published?
No, that's okay, Judge.
Okay, we're good. And then, all right,
Can I have just a moment?
yes.
So they were confirming right there that all of the evidence they put forth was indeed admitted into evidence. And that was what they were trying to accomplish with the previous witness.
Your Honor, the
Sorry.
state rests its case in chief.
Thank you. Turning to defense. Approach the bench, please.
So the state has rested its case in chief, and they put forth a lot of evidence and were able to get it all admitted. Again, like I was saying, that was the purpose of the previous witness, Sergeant Falmina. She was able to authenticate a number of different pieces of evidence, and that's why they were double checking before they rested. They wanted to make sure everything had been admitted. If not, they would have had to recall somebody. So now the defense has the option to present any witnesses that they would like in terms of putting forth their side. Of course, they don't have to. Again, this is not a trial, so there's not the burden of proof beyond a reasonable doubt here. That's not what this is. This is a preliminary hearing. The bar is much low. Basically, the state is trying to prove to the judge that there's probable cause here, that a crime was committed, and that it was likely committed by Tyler Robinson. So this is a very, very low bar here. And with everything that's been put forth, I don't think it's very likely that the judge would not move forward. I think it's very likely the judge will move forward. And again, it's a judge deciding this, not a jury here.
Get situated. All right, counsel, your request.
Your Honor, as the court knows, the family has asked that all exhibits admitted into evidence be shown here in open court. We are grateful to the court for allowing the family to view many or most of the exhibits today that were admitted. They were viewed here openly in court. And obviously that was done after the court struck what we think is the appropriate balance after a very thoughtful and thorough analysis. I'm going to ask the court to reconsider one of its prior rulings. I understand reconsideration is always a big ask, but I do think, Your Honor, that if the court were to display publicly, or just in the courtroom, Exhibit 12.1, which is the enhanced video, version 12.4, which was played in court, was very hard for the family to view. We think that we asked the court, that since the court's considering it, the family should be able to view it as well. When conducting the appropriate balancing, the court, as the court knows, can alleviate any concerns about proper jury selection with certain tools at its disposal. However, if the court were to deny the family the right to view that video, there's no cure. It's either they get to view it or they don't. So we would ask the court to reconsider its prior ruling and to display just in the courtroom Exhibit 12.1, which is the enhanced video. Thank you, Your Honor.
Thank you. Turning to the parties, starting with the state, Mr. Grunander.
Thank you, Judge. The state does not oppose publishing 12.4 in the courtroom. I think we've tried to make it very clear throughout this case that we favor openness and transparency as much as appropriate. I'll submit it on that.
Thank you, Mr. Grunander. To defense, Mr. Burt.
My apologies. That's 12.1, not 12.4.
Thank you.
Judge, at this point in the proceeding, we're asking the court to keep focus on the purpose of this hearing. And as the justices said in the Estes case, the purpose of a trial, and I know this isn't a trial, but the same logic applies, is to determine the defendant's guilt. It's not to educate the public or the victim's family or the world on what evidence the government or the state has. As the court knows, we have witness availability problems. We spent the bulk of today and yesterday arguing about nothing to do with the evidence in the case, but with rights of third parties. And it's appropriate for the court to consider that. But at some point, I think the court has to return to the purpose of these hearings, which is to expeditiously hear the evidence and then determine probable cause. And I want to point out to the court, Ms. Kirk has been very adept at holding press conferences at which she has revealed evidence. She has represented that the state is her attorney. She has access to all the evidence that the state has publicized and that the media and her own lawyer argues is already in the public domain. So they're perfectly free to go outside this courtroom under the court's protective order. They're free to go out and hold press conferences and announce to the world outside the courtroom what they think the evidence is. They have the availability of that evidence. But the court's role, I think, at some point is to exercise some control, move the case forward, and especially when we have witness availability problems. And I'd ask the court, whatever the court does, if you're going to allow revisiting or replaying of evidence for the sole purpose of informing the world or Ms. Kirk or anybody else, that the court do it at the end of the process and not at this point where we will be deprived of our ability to call this witness, because she has to be done today.
Thank you, Mr. Byrd.
Thank you.
Briefly, and I say that because time is of the essence, not because I don't want to hear what you have to say.
I understand, but there was a lot that was just said that's just not true.
Well, so let me put this in the spot where we need to be. I understand that there's opinions, but I have to keep this to the probable cause. I don't want this to go to a back and forth about issues that lie outside of probable cause. And I realize statements are made, and as the victim's representative attorney, you want to address it. So I will hear you, but we need to be brief. So if you can be succinct, I definitely want to hear what you have to say.
Your Honor, I am almost always brief, I promise you. The family's not seen this video. It hasn't. It doesn't have access to the evidence the state has. The state is the state, and Ms. Kirk and the family have their representatives. There's a completely distortion of reality that was just put forth. And this isn't about educating anybody about anything. This is about allowing the family to see the evidence that's been gathered after a 10-month investigation in which a father, a husband was assassinated. That's what this is about. So we ask you to please allow the family to view the video like the court has viewed in order to allow the family to process this moment.
Thank you.
Thank you.
Anything further before the court issues its ruling and we go from there?
Not from the state.
All right. Defense? All right. All right. So I recognize that the Utah Constitution under Article 1, Section 28 recognizes victims' rights, and the court respects those rights, and as it's been previously stated, balances those rights with the constitutional rights of all parties. I will reserve my ruling on that and maybe revisit it tomorrow. But because we have an issue of expiring time and one witness that needs to leave today, I need to turn to that. I'm not ruling that that cannot happen, but for today, we need to focus on this to getting this defense witness on the stand and off the stand. And so please, if I do not remember, the parties can remind me and we can revisit this tomorrow. So again, I'm not saying yes, I'm not saying no. I'm simply saying we need to get to this witness, and I'm happy to readdress this tomorrow. Okay? All right. Mr. Burt. All right. Samantha Karner is being requested. If you can go ahead and retrieve her.
Yes.
Bring her into the courtroom.
Someone is doing that.
Is somebody grabbing her?
Yes.
Okay. Thank you, Mr. Burt. I just couldn't tell and wanted to make sure.
So to point out, this judge is being extremely fair. He's in a very, very difficult
All right, Mr.
position.
Partner, if you wouldn't mind coming forward, right by our bailiff to be sworn in.
And this is the defense's first witness. Apparently is on limited time constraints and has to be finished by today.
Please raise your hand. Do you solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, thank you, ma'am. If you wouldn't mind coming forward, having a seat at the witness stand. To your left is a water bottle if you choose. It looks like you brought your own as well. And after you're situated, if you wouldn't mind pulling that microphone toward you, just to ensure that your testimony is picked up on the record. Mr. Burt, your witness.
Thank you. Good afternoon. Could you tell us your name, please?
Yes, my name is Samantha Karner.
And Ms. Carter, what do you do for a living?
I am a firearm and toolmark examiner.
And where are you stationed?
I currently work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And how long have you been employed at that location?
A little over 6 years.
What generally do you do there? What area of expertise do you have?
I am assigned to the firearm and toolmark unit, so I receive items of evidence related to firearms, tools, toolmarks, and fired ammunition components.
At the request of the state of Utah, did you conduct certain examinations relevant to this case?
I did, yes.
Could you bring up State 32 in evidence?
Do you want it, Mr. Burt?
Yes, I think.
On all screens?
All screens, it's admitted and
Okay.
I think
All
approved for
right, let's go ahead and put
publication.
it on all screens because this was admitted and published previously. All right.
You recognize plaintiff's exhibit number 32?
I do, yes.
Are you the author of this report?
I am, yes.
Okay. What were you asked to do in relation to the examination that's documented in this report?
For the submission 1 report, I received a firearm, cartridge case, 3 cartridges, 1 bullet jacket fragment, and 4 lead fragments. I was asked to test fire the firearm and compare the test fires to the cartridge case and the bullet jacket fragment. I also was asked to do a tool mark characterization on the cartridge case and the cartridges. And then I also ran a general rifling characteristic search on the bullet jacket fragment.
Okay. And are your conclusions accurately documented in your report?
Yes.
Could you turn to page 2 of the report? Second, bottom of the page. Those 2 paragraphs, please. Did you write in your report, these conclusions conform with the relevant Department of Justice policy on uniform language for testimony?
Yes, that is always added to our reports.
And do you have a standard operating procedure that requires that in each examination you do, this language has to be in there?
We do, yes.
Okay. And I want to ask you to review the document that is referenced in that language, which would be, and this is just for her only, Exhibit 11. Let me know when you can see that. Are you able to view that?
Yes,
Is this the ATS? Is this a language referred to in your report?
it is, yes.
The written policy of the Department of Justice concerning uniform language for testimony and reports for the forensic firearm toolmark discipline pattern examination?
It is, yes.
I move that into evidence.
This is, what is the title of this exhibit?
Your Honor, this would be Carner 11.
All right, and what level of publication are you requesting, Mr. Burt?
Both public and admittance into evidence.
To this date?
No objection.
All right, Carner 11 is admitted into evidence and may be published on screens and captured by the camera.
Thank you. And you can publish that? Ms. Carnick, can you tell us what the purpose and scope of this document is?
Yes, this is the DOJ Department of Justice's uniform language for testimony and report, and it standardizes the appropriate language an examiner will use during reporting and their testimony. And DOJ published this to standardize the wording that examiners would use across their forensic laboratories.
And was this published in part because of some criticism that the prior testimony, not by you, but by other people, may have gone beyond the bounds of science?
I don't know why DOJ published it. It was before my time.
Do you know how long this has been the policy of the Department of Justice?
I do not off the top of my head, no.
Are the reports that you issued in relation to this case in conformity with this policy?
They are, yes.
Okay. Now, could you go to page 3 of that report? Where it says qualifications and limitation of firearm tool mark discipline examination. You're familiar with that part of the policy, correct?
I am, yes.
And the portion of the policy that says a conclusion provided during testimony or in a report is ultimately an examiner's decision and is not based on a statistically derived or verified measurement or comparison to all other firearms or tool marks. Therefore, an examiner shall not, and then it lists several propositions. You're familiar with that language?
I am, yes.
And it says that an examiner shall not assert that a source identification or a source exclusion conclusion is based on uniqueness of an item of evidence. Your report is not meant to imply something contrary to what's stated here, is it?
No, it's not meant to contract.
You're not asserting that a source identification is based on the uniqueness of an item of evidence.
No, I am not.
And the reason you're not doing that is because you haven't examined all possible items of evidence that could be relevant to your comparisons, correct?
I have not looked at every firearm that's been manufactured in the world, nor have I looked at every tool that's been manufactured in the world. That's correct.
Okay. The second portion of that says an examiner shall not use the term individualize or individualization when describing a source conclusion. Did you abide by that policy in this case?
I did, yes.
And you're not expressing an opinion here that the comparisons that you made are individualized to a particular weapon or a particular cartridge case, correct?
My conclusion for one of the exhibits identifies the cartridge case as being fired in the firearm.
Mhm.
But that's all it says, yes.
Right, but you're not asserting that that's an individualized identification in the sense that's being used in this policy, are you?
No, I am not.
Okay, and then the third part of that says that an examiner shall not assert that two tool marks originated from the same source to the exclusion of all other sources. You're not expressing that opinion either, are you?
I am not, no.
It says an examiner shall not assert that examinations conducted in the forensic firearms tool mark discipline are infallible. You're not asserting that.
I am not, no.
You're not asserting that, says the examiner shall not assert that there is a zero error rate. You're not
Correct.
making that assertion,
No.
okay? Says an examiner shall not provide a conclusion that includes a statistic or numerical degree of probability except when based on relevant and appropriate data. You didn't conduct such an analysis here, correct?
I did not, no.
Okay. And it says, an examiner shall not cite the number of examinations conducted in the forensic firearm tool mark discipline performed in his or her career as a direct measure for the accuracy of a conclusion provided. You didn't do that and you're not doing that here, correct?
Correct.
And then it says, an examiner shall not assert that two tool marks originated from the same source with absolute or 100% certainty, or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony, unless required to do so by a judge. You're not making any such assertions in this case, are you?
I am not.
Okay. All right, thank you. You can take that down. Now, when you conducted your analysis in this case, and in all cases, do you typically generate a case file that includes proper documentation of your examination?
I do, yes.
And did you do that in this case?
I did.
Could you display to her alone, please, Exhibit 6, Carner 6? Case file. Yes. Do you see what's displayed there?
I do, yes.
It's a 47-page. Is this your case file?
It is, yes.
Did you rely on the documents and photographs that are documented here in writing the report that the state introduced into evidence here?
How so?
Before you wrote your report, did you photograph items that you were looking at, take other notes, and then use that work product to form the opinions you reached that are documented in the report?
The notes are mostly used for initial documentation and evaluation, and then yes, supplement to the conclusions that I make. It's all a representative image of what my conclusions are going to be. So part of it is going into the conclusion statement and then just showing proof of those conclusions.
Right, and your standard operating procedure requires that you document in your case file the basis for your opinions, correct?
Yes.
I'd move Carner 6 into evidence.
To the state.
Is this the 47-page document?
Yes.
I object. I don't see the relevance to the court's probable cause determination to review a 46-page report that includes notes.
Would you like to respond, Mr. Burke?
Yes, Your Honor, this is the basis and documentation of the conclusions reached in the expert's brief report, which expresses her ultimate conclusion, but does not contain any of the reasoning for that conclusion. So it's important for the court, I think, to understand why and how she reached the conclusions that she did.
All right. Anything further?
No?
Yes, just that without testimony about what the meaning of the notes is and so forth, it is more confusing than it is probative. So under a 403 analysis, I don't think it's admissible nor helpful to the state, to the court.
All right. Mr. Burke?
I intend to focus on particular photographs which document what she received in evidence and the comparisons that she did, which are also documented in this file in the way of comparison photographs.
All right. As it relates to the objection is overruled. I find that this is relevant as it relates to State's Exhibit 30, which was admitted, as well as State's Exhibit 32, which is admitted, and the state is able to do cross-examination on this witness as it relates to this report. And so it is admitted and may be published on all levels in the courtroom and through the media.
Thank you. Ms. Carner, one of the items you were asked to look at was, as described in your report, 1 bullet jacket fragment and 4 lead fragments, correct?
Yes.
Were you informed at some point that there was a discrepancy between what you were examining and what had been documented by the medical examiner in terms of the number of bullet fragments?
I was, yes.
Were you asked to see if maybe the ATF had lost certain portions of the evidence?
No, I was not.
Right. Do you think, and was it your understanding that there were originally 7 bullet fragments, but you ended up with 4?
I was alerted that there was potentially 7 fragments from the medical examiner in a photo just a few months ago.
Okay. You're clear, though, that when you got the evidence, it was in a sealed condition, correct?
It was, yes.
And when you opened, what was it, an envelope?
A small individual manila envelope, yes.
And did you take the contents of the envelope containing the bullet and take photographs of it?
I did, yes.
Okay. Could you display page 41 of 47, that exhibit? I'm sorry, page 14. And tell us what's depicted here.
Yes, this is a picture of the as-received condition of Exhibit 6 in its entirety. That's the top picture. So you'll see Exhibit 6A all the way through 6E in descending order. And then the bottom two photos on the left is the Exhibit 6A bullet jacket fragment, and that is the view of the exterior. And then the photograph on the right is the Exhibit 6A bullet jacket fragment, and that's the view of the interior of it.
Okay. Now, after you documented what the bullet and the fragments look like, did you do certain procedures on the bullet, the larger bullet fragment?
I did, yes.
And what did you do?
I cleaned the bullet jacket fragment, and I also peeled the petals back. If you think of a banana and peeling the skin away from the interior, it's almost like doing that. As you can see from the photo, the petals have been crumpled in on themselves. So in order for me to see the land and groove impressions, which holds those individual characteristics needed for a comparison, I have to do some maneuvering of those petals.
And how do you do that? Do you use an instrument to peel back the portions that you want to look at?
I use pliers.
Okay. And after you did that procedure, did you then photograph the larger bullet fragment itself?
I did, yes.
Were the smaller fragments essentially not of any value to you in terms of doing comparisons?
They were deemed unsuitable, which means there are no microscopic marks of value for comparison.
Okay, but the larger fragment, after you did the process you just explained, you then photographed it again, correct?
That is correct, yes.
Could you display the next page of this exhibit, please? Tell us what we see here.
This is two pictures of that 6A bullet jacket fragment after the examination preparation. So the top photo is going to be the interior of 6A, and then the bottom photo is the exterior of 6A.
Now, after you took these photographs, did you proceed to do something to determine whether you had either class, individual, or subclass characteristics?
Yes.
Tell the court what that means.
To start, when I do my initial examination of a bullet jacket fragment like this, I'm going to look at its class characteristics. Class characteristics are the least restrictive set of characteristics I use in my comparison process. And these are design features that are given to a large group of items that characterize them together. So for a bullet, you could think of the diameter of the bullet, the number of landing grooves, the direction of twist, and the type of rifling. So I would go through and look at the class characteristics of this bullet jacket fragment, which was 6 right conventional rifling. Then I'd move on to look at any subclass characteristics. And subclass characteristics are more restricted than class, but less than individual. And they are design features that can be put on an object during the manufacturing process, which is consistent among items that are made by a tool that's in a specific state of wear. So what I mean by that is it's going to be a subset of a larger group, which is why it's not used for identification or comparison purposes for the basis of a conclusion. But when you think of something that's made through a mold process, when that mold comes together, it creates a seam line, and that seam line is going to be represented on all the items that it makes. So that's why you can't use it for the identification process, because it's going to be on a lot of items, which is why it's a subset of the group. Then I move on and looking at the individual characteristics. And these are imperfections and irregularities that arise from the manufacturing process. And then there's also individual characteristics can arise from wear, use, and abuse of a tool. And these individual characteristics is what is going to be distinct to that tool, and that's why they're used for the identification process. So again, I did an examination of its class characteristics, looked for any subclass characteristics, and then looked to see if there was individual characteristics in the land and groove impressions sufficient enough of marks and values to do a comparison process.
Now, once you have the class characteristics of a bullet, can you narrow the range of firearms that could have fired it just based on class characteristics?
You can, yes.
And is caliber a class characteristic or an individual or a subclass characteristic?
It's going to be a class characteristic because a lot of firearms will have the same class, or excuse me, the same caliber.
Did you measure the diameter of the bullet?
I did, yes.
And did you end up with a range where it could have been certain range of length or diameter?
I did, yes.
And what was your reading?
Can I refer to my notes,
Yes,
please?
please.
The range of the diameter for the 6A bullet jacket fragment was 0.286 to 0.301 inches.
Okay, what page are you looking at?
It's page 13.
Okay. Now, so this is your documentation of the diameter measurement. And then on the right there, LIMP, that's measurement of the land width,
The
correct?
land impression width, yes.
And these are all general characteristics or class characteristics, right?
Correct.
Okay. Now, once you had that this, and also that it was, you said, what's called the rifling was to the right, correct?
The direction of twist, yes.
Yeah, the lingo is 6 to the right, meaning,
6 right, yes.
and that's a class characteristic.
Correct.
So once you had the diameter of the base of the bullet, and did you have some difficulty because of the damage to the bullet in exactly measuring it?
The reason I provided a range was because of the damage and deformity to the base. So at times it wasn't a perfect circle. So it was important to me to give a range of what those diameter measurements were.
Once you have the diameter and the rifling characteristics and the land and groove measurements, can you then plug those measurements into a database and to narrow down the class of weapons from which this bullet could have been fired?
The general rifling characteristics search will use those class characteristics and will generate a list of possible firearms that could have fired the bullet. But that list is not all inclusive. It is just used as an investigative tool.
Sure. Could you go to page 47, please? Could you tell us what we're looking at here?
This is the results of that general rifling characteristic, or the GRC search.
All right, and what did you determine in terms of, just based on the class characteristics, what weapons could have fired the 6A bullet?
There were several different 30 caliber class firearms that could have fired the bullet.
And they're listed here, correct?
Correct.
Could you tell us what the initials PI and RI and PR mean in the far right-hand column?
They refer to different types of firearms, so rifles, revolvers, machine guns, any type of firearm.
And what are the pistol ones? How is that designated? PI or,
Correct.
and what is RB?
Bolt action?
Bolt action. So based on the class characteristics, any of these weapons could have fired that bullet.
They could have possibly fired the bullet jacket fragment, yes.
Okay. Now let's go back to the examination of the other two measures, subclass characteristics and individual characteristics. Is one of the reasons you look at subclass characteristics because they can be confused with individual characteristics.
That is a concern, yes.
In fact, your manual says that, right? It's important to rule in or out subclass characteristics to avoid the danger of confusing them with individual characteristics.
I'm not sure if our manual says it verbatim. It says that we do need to assess every piece of evidence for possible subclass characteristics.
And what is the reason for that?
Subclass characteristics can be similar to individual characteristics. However, trained examiners are able to notice the difference between subclass and individual. Subclass characteristics are not always present on an item. It's possible, but not always present. And they tend to look a certain way. They're going to be uniform in their appearance. They're going to be spaced in a way that's more uniform. If you think of circles, those circles could be a distance between each other in the same distance every time, and they will look almost the exact same every time.
Now, does your laboratory have certain protocols for conducting these comparisons?
We have procedures for comparison, yes, like taking photographs, yes.
Well, but also procedures for for instance, you have a document called Examination and Comparison of Unfired and Fired Ammunition and Components that deals specifically with the procedures to be followed for the kind of examination you did here, correct?
Yes, I believe that refers to the minimal documentation necessary for a piece of evidence.
And one of those standard operating procedure requirements is document observations and evaluate for the potential of subclass characteristics on the relevant tool working surface, right?
Correct, yes.
And you did that in this case, correct?
I did, yes.
Okay. And what conclusions did you reach?
Can I refer to my notes?
Yes,
please?
please.
My subclass assessment that's on page 13 of my report states, stria observed in the land and groove impressions contain starts and stops, are not coarse, and vary in their height, width, depth, and spatial arrangement. No apparent subclass influence.
Okay. And what page was that again?
Page 13.
Page 13. Let me ask you about that. The striae observed are not coarse. I think I understand that. And vary in their height, width, depth, and spatial arrangement. Did you measure the height, width, depth of the land and groove impressions?
The land and groove impression widths, yes, I did.
And how about the striae? That's different than the land and groove impression, right?
Correct, yes.
You didn't measure the height, width, and depth of those marks, correct?
No, I did not.
Okay. And your protocol says, does it not, due to their similarity to and potential confusion with individual characteristics, it is essential that the evidence be evaluated for the potential of subclass characteristics.
It does, yes.
That's the whole purpose of why you're doing that part of the exam, right?
Correct, yes.
And anywhere in your protocols, does it specify what you're looking for, or is it just up to you to decide what is and what is not a subclass characteristic?
Subclass characteristics are a very large part of the training process to become a firearm and tool mark examiner. There are modules that are taught where you're trained to recognize what subclass characteristics look like, what manufacturing techniques might lend to more subclass characteristics. So I am trained to know what it looks like.
Okay, and my question now was, does your standard operating procedure set out, here are the things you should be looking for? For instance, does it say if what the marks you're looking at are not coarse and vary in their height, weight, depth, and spatial arrangement, or if they're perpendicular on the barrel, that indicates that it's not a subclass characteristic? Is there anything like that in the manual?
No, there's not.
Okay. Did you inspect the interior of this barrel?
I did, yes.
And did you notice whether it had any debris or dust in it?
I believe my notes state that debris and dust was observed in the inside of the barrel, yes.
Okay, and could you further characterize what that was? Debris,
I think it says dust, so I would say dust.
dust. What can cause dust to get inside of a barrel?
A plethora of things. I'm not sure why something is ever in a barrel.
Okay. So you determined here, you ruled out subclass characteristics, correct?
Yes,
Then the next part of the examination was determining whether you had any individual characteristics on the bullet, correct?
yes.
And what did you conclude in that regard?
That there were microscopic marks of value worthy of comparison, or yes, individual characteristics in the land and groove impressions.
And does your standard operating procedure have any guidance in terms of how you go about determining that?
No, I do not believe so.
Okay. And then once you determine that you have items of value on the question bullet, do you then do something to produce test bullets?
Yes, part of the comparison process when there is a firearm that we receive is to test fire it to make pristine samples to see if reproducible individual marks of value is on the bullet or the cartridge cases.
How many test fires did you produce in this case?
I made 3 sets, so 6 total.
Is that your standard number of test fires?
Our standard operating procedures state that you need at least 2. There is not a maximum number that we are allowed to do. It's the discretion of the examiner.
Were you informed by other investigators working on the case that this particular weapon was manufactured in Germany in 1938?
I was not, no.
You did not review a report from an ATF agent who investigated that issue?
No, I don't believe so, no.
In doing your examinations, is it important to know something about the manufacturing process of the weapon?
It is helpful to know how a barrel or any part of the firearm is manufactured, yes.
And why is that?
Certain manufacturing techniques will lend to that individual characteristics. So grinding is a method that is known to leave individual characteristics on a tool. So if a item that I receive, I can tell is finished or manufactured by grinding, it already gives me an indication that individual characteristics would be left from that tool to the tool mark.
Now, once you have your 6 test fires, then you did some comparison between the test fires, right?
That is correct, yes.
And why do you do that?
That establishes whether or not there are individual reproducible marks of value on the test fires. It's important to know that because if there's not reproducibility amongst the test fires, then there's a chance to say, oh, it's not going to reproduce on the evidence and I wouldn't have anything to compare it to.
And have you had cases where you fired the 6 test fires and you don't get reproducible marks?
Not that I can recall.
And when you do your comparisons, just looking at the test fires, do you get situations where there's some dissimilarities between those 2 fired bullets from your test fires?
Yes, there are at times there will be disagreement amongst the individual characteristics, even in test fires. You have to think of it as when a bullet travels down a barrel or a cartridge case interacts with a firearm, the marks aren't going to be left onto that item the same way 100% of the time. It's almost like a stamp. If you know you're using a stamp and you put it in ink and then you put it on 2 separate areas of an item, it might look a little different just from the way the stamp was placed. It's the same thing with a bullet traveling down a barrel or a cartridge case coming into contact with a firearm.
So even when you know a bullet is fired from the same weapon, you can have 6 bullets fired. And when you start comparing them, you will see differences between each bullet.
There is a possibility to see some areas of disagreement. However, if I'm rendering an identification and saying there is reproducible individual marks of value on these test fires, there will be an overwhelming amount of sufficient agreement of that individual characteristic.
Now, when you're doing these comparisons, you use something called the AFTE theory of identification, don't you?
Yes, the AFTE theory of identification.
All right, and take a look. And that's the standard that you used in this case to draw the conclusions that you made in the report that I showed you earlier, correct?
That is the theory stating how an examiner is able to come to a conclusion when examining 2 or more sets of tool marks. And yes, that is how I go through my examination and how I come up with my conclusion, yes.
Okay, and what is AFTE?
AFTE is the Association of Firearm and Toolmark Examiners. It's the governing body of the firearm and toolmark community, whose primary goal is to further research and continue to show information about manufacturing and the evolution of firearm and toolmark examination. They hold annual seminars, publish a glossary of terminologies used by the firearm community, and they also have a peer-reviewed published journal.
Peer-reviewed published journal. Can I join AFTE?
You can, most of the firearms community, members are firearm and toolmark examiners. There are also technical advisors and associate members.
Mm-hmm.
Those members are not usually firearm and toolmark examiners, but they still have a livelihood in firearm and toolmark examination, meaning they conduct research or they are involved in products or manufacturing. And anybody is allowed to come to the annual seminar or get the journal. You just have to pay the fee.
Just have to pay the fee. Okay. Could you display to the witness exhibit 27, please? Do you recognize what's displayed here?
It appears to be the AFTE theory of identification, yes.
All right, I moved that into evidence, Your Honor.
What is it?
This is the standard that she used to make the comparisons in this case, correct?
This would be Carner 27
This would be Carner 27, Your Honor.
to the state.
Your Honor, if I may voir dire the witness on this exhibit, I've never seen it before, I don't think.
All right,
Sure.
let's go ahead and do so, Mr. McBride.
When was the last time you reviewed this document?
I'm not sure off the top of my head.
Can you testify as to its accuracy by looking at it now?
Not verbatim, no.
Your Honor, no more questions. My objection is lack of foundation.
Yeah. So voir dire is the legal process in which attorneys and judges question prospective jurors usually. You can also do this to inquire with a witness on the stand like we have here. Basically, what's happening is the defense is trying to get a piece of evidence moved or an exhibit moved into evidence. However, the prosecution is challenging that. They're challenging the lack of foundation, meaning she may not have direct knowledge.
I believe something, I think the first statement is different than what I can recall, but overall it is what the active theory states.
Okay. And your ATF protocol refers specifically to the AFTI theory of identification, does it not?
It does, yes.
Okay. So is there any difference between what's in 27 and what's in your manual?
Again, I don't remember without looking at them side by side.
Okay. Let me get that in front of you. Let's go to Exhibit 12. And go to theory of identification and range of conclusions. Page 1 of 3, and I have the dates on it toward the end. It's document FT 10. No, that's not it. Could I put you in, Charlie?
You may.
Page 1 of 3 of your protocol.
So while she's
I
reviewing this,
recognize this as something that comes from our SOPs, yes.
Okay. And it refers to the AFTI theory of identification, right?
It does, yes.
Same theory that's displayed in 27.
Yes.
Okay, so I'd renew my offer on 27.
Your Honor, the objection stands. Language matters. Without knowing what, if this language is identical to what she's trained on, that can make a big difference. Whether the word sufficient or adequate is used, these are scientific principles and we need to be precise in the language that's used. The witness cannot authenticate the exhibit that's been offered, so it should not be received into evidence.
Mr. Burke.
Goes to weight, not admissibility. You'd be free to question her about any differences, but I think she's laid a foundation that the theory is the same. So,
All right. Well, I remind the parties that this is a probable cause finding, and so as it relates to what's been presented, the witness has said that it looks familiar. Again, I don't want to quote you, I don't remember the exact phrase, but she recognized portions of it and then was given the opportunity to compare it to her standard operating procedure. I think she said SOP. For those reasons, Corner 27
Yes.
is admitted and may be
Thank you.
published.
Again, this is a preliminary hearing, so much lower bar. They're just trying to prove probable cause. This is not a trial.
I'm
The
looking
judge
at
is
the
way more
language of
than-
this, the second part of it, according to AFTI, says currently the interpretation of individualization, identification is subjective in nature. Do you agree with that?
Yes.
Why is it subjective in nature?
The conclusions that I author are of my opinion.
Of your opinion?
Correct.
Does your, you can take that down, thank you. And no, wait a minute, go back if you would. But while he's doing that, does your manual state what you're looking for under this theory is correspondence of individual characteristics?
Yes.
That the theory is that if you see a certain level of correspondence, you can make a source identification, but not to the exclusion of all other firearms in the world, correct?
Correct.
Okay. And the standard, at least as it's articulated here, is the theory as it pertains to the comparison enables opinions of common origin to be made when the unique surface contours of two tool marks are, quote, in sufficient agreement. And is the subjective part of that, the quoted part, sufficient agreement?
The subjective part of the conclusion is saying, yes, it is my opinion that there is or is not sufficient agreement or sufficient disagreement amongst two or more tool marks.
And what may constitute sufficient for you may be completely different from the next examiner. Fair?
Yes and no. I would expect any trained, competent examiner to come to the same conclusion. So the threshold of sufficient agreement might be different from one examiner, but the conclusion I would expect to be the same.
Does your manual state, your ATF manual, section 431, state that correspondence or lack thereof of individual characteristics is not easily communicated? An observation such as significant agreement can mean different things to each examiner. This does not serve as interpretable descriptions of what was observed because the individual performing the review will likely have his or her own concept of the phrase based upon their training, experience, and knowledge.
Objection, Your Honor. This question goes to weight. Oh, I'm sorry. You don't, may I be heard?
If you're objecting, I will hear the
It's
objection.
just speaking objection. That's why I stopped myself. This goes to weight. This goes to credibility. And the witness's report has already been admitted as is appropriate under the Utah Constitution, Rule 7B and Rule 1102 of the Rules of Evidence. This is beyond the scope of preliminary hearing for those reasons.
Mr. Burt.
Number one, that's a general objection, which I think has been waived. The state was privy to the interview with this pre-hearing interview with this witness where these same questions were asked. We had a scheduled hearing where the court was going to rule on objections. The state indicated in advance of that hearing that it had no objections to the testimony, reserving the right to make particular objections. But the objection being made is a global one. And it's relevant because the state offered the evidence I'm offering here is relevant because the state offered through a hearsay declarant the meaning of this report that this examiner authored. And I'm trying to inform the court on what the limitations are of the opinions expressed in the report that the state offered. And it's certainly relevant to the reliability issue to know that the opinion is based on a subjective standard that the witness herself admits is subjective. So I think it helps the court understand what weight, if any, to give to this report that the state offers.
Mr. McBride, final thought.
That's all fine, but it's inviting the court to weigh the evidence. That's the whole point. And at this point, the inferences are drawn in the state's favor, and the court is not to weigh even contrary evidence.
Well, in regards to whether objections have been waived or not, the court as the magistrate bears the ultimate responsibility to ensuring that this hearing is a probable cause standard. And so that's a responsibility that as a magistrate I take seriously. I understand the arguments from the parties. I'm going to overrule the objection, but Mr. Burt, this is, we don't need to go 100 miles down a path where 1 mile is where probable cause may be. And so I invite you to refocus, to bring it
Sure.
to the probable cause. I'm not trying to limit what your theories or such, but I need to hold to probable cause.
Absolutely, and I don't even need a quarter of a mile. This is my last question, and I'm going to move to another
All right.
topic.
Thank you, Mr. Burt.
Is that what your manual states?
I don't remember it verbatim, but it does sound accurate.
Well, could you pull up Exhibit 12, page? Just to. Can I approach again?
You may.
I'll give you the 2 pages. Bottom of the page, highlight.
I see where you were reading from. Yes.
You see,
Yes,
did I accurately read it?
I believe so. Yes.
Thank you. Can I approach again?
You may.
Now let's return to the report, the People's or State 32. And if you would go to the second page, please. You concluded here, did you not, that the Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1A based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The result of the comparison was inconclusive.
Yes.
That was your ultimate conclusion, right?
Yes.
And on the next page, if you would go to 2 pages in, you have an appendix, do you not, where you explain what inconclusive means? Next page, one more. There we go. I want to ask you, because I'm unclear on what inconclusive mean. You say reasons for an inconclusive or include the presence of microscopic similarity that is insufficient to form the conclusion of source identification, a lack of any observed microscopic similarity, or a microscopic similarity that is insufficient to form the conclusion of source exclusion. Could you specify which of those possibilities exists in this case? Was this a case where you had microscopic dissimilarity, but in your opinion, it was insufficient to form a conclusion of source exclusion?
No, my conclusion is inconclusive, just as it says in the appendix. There's a lack of sufficient agreement and sufficient disagreement, so I'm unable to say one way or another.
Okay, but I guess my question is, were there points of dissimilarity between the question and the known bullets?
Again, there was sufficient agreement and there was not sufficient agreement or sufficient disagreement. So yes, there was times that I saw agreement in the striations and the land and group impressions, also seeing disagreement, but there was also a lot of lack of microscopic marks of value to see it all. So because of this lack of quality and quantity of marks to be able to see, it never reached the threshold of sufficient agreement nor sufficient disagreement. So an identification or exclusion could not be rendered.
Okay, I think you and I met before today, correct?
Yes,
Where we talked about what that term inconclusive meant, correct?
Yes.
And I think, and correct me if I'm wrong, but did I read to you from a do you recall me asking you whether you agreed with this statement that an inconclusive conclusion indicates that the microscopic marks in question may or may not have originated from the same or known source?
I do remember you asking, yes.
And you agreed that that was a correct definition of what you concluded in this case, correct?
Correct, yes.
Okay. So I want to, if I could, return to 10, Exhibit 10. And in Exhibit 10, not 10, I'm sorry, your case file again. This is the 47-page document. There we go. What's the tab? 6. Okay. In your case file, you have produced for us some nice comparison photos of your comparisons, correct?
Yes.
Okay. And if you would go to page 37. Is the top photo depicting one test fire on the left and another test fire from the same gun on the right?
Yes, it is.
So do you see areas of agreement and areas of disagreement in these two bullets fired from the same rifle?
I see sufficient agreement amongst the striations that are in this land impression.
Okay, and tell us where they are. When you draw that conclusion using this subjective theory of identification, show us what you're looking at.
Is it touchscreen?
Probably,
No, it's,
No.
I'm sorry.
but we can, if you direct us, we can get there with a pointer.
Sure. So you can see towards maybe the last third of the bullet or the land impression that, yes, right where your cursor is below there, that's an area of agreement with that striation. It looks like it's going from the left to the right. So that mark is appearing on the test fire on the left and the test fire on the right. Then if you look towards the top of that land impression, there's going to be some more lighter colored striations or lines that are moving from left to right. Those areas are in agreement as well.
Where is that? Not as far up as where he is, correct? It's down.
Yes, and I believe the PowerPoint that I provided does have some areas and circles of some of these marks, if that would help as well. But if you move your cursor up, continually up, keep going. There you go. You have a line that was right there, and you have several others underneath of it that looks like it's going just straight across from left to right, and that shows an observed area of agreement.
So that one he's got circled on the right, I see a line there. Are you saying you see a line on the left that it's identical to the one on the right?
I'm saying I see agreement amongst those striations, yes.
Okay, anything other than those two areas?
You can really go down the entirety almost of that line looking at those striations. So under the top red circle, there's another area there. Yep, if you start right there and you draw your circle over, like I said, at the top of the circle, there's a highlighted line on the left that goes all the way to the right. If you go a little bit farther down, maybe still in the top third of that circle, you can see another line going from one side to the other, another area of agreement as well. And then under the final third circle, in a little darker area down there, there's still some lines, again, in sufficient agreement.
Okay, and again, these are comparisons between test fires. So you know the rifle that you're test firing fired these two bullets, right?
Yes, and the
Okay.
purpose of those test fires is to ensure that though it was fired from the same firearm, you want to make sure that those individual characteristics are reproducing.
All right, so go to the photo on the bottom of that page. This is the first of several comparisons between the test fire on the left and 6A on the right, correct?
Yes.
And what does the writing on the top mean? Blue index, GIMP?
So that will be, the first number there is the case number, the laboratory case number. Then next 1.11B is going to refer to the specific test fire that's on the picture.
Mhm.
And then V versus 6A, so that's the evidence that's also pictured. GIMP stands for groove impression. So I'm looking at a groove impression in this photo. Blue index means I'm specifically looking at the groove impression that I have put a blue indexing mark on so that I know where I am during the comparison process.
Okay.
30X refers to the magnification that the photo was taken at. And then INC refers to inconclusive, the final conclusion.
So I'm interested in the areas of disagreement. Are there areas of disagreement between the known and the unknown here that you could point us to?
So for this photo, to me, I see areas of agreement in the top.
Mhm.
And then on the way down from the 6A, right after you see those two highlighted lines near the top, there's a lot of damage that is observed and almost no microscopic marks of value can be observed at all. So again, that lends to the lack of quality and quantity of marks even to do a comparison. It's almost like missing data points.
Okay, missing is not the same thing as dissimilar though, right?
It just means there's nothing there to call agreement or disagreement.
So do you see areas of disagreement here or no?
On the striations that are available to me on this groove impression, I see areas of agreement and specifically talking about those two highlighted lines at the top on the right.
Okay, go to the next page, please. Top photo on the next page. It's B38. You see areas of disagreement in this photo.
So this is the same photograph that we looked at before, just at a different magnification. It's zoomed in a little bit more from 30 to 40x. So again, I'm looking at those two highlighted lines near the top. And then if you look down, you can almost see that damage a little bit better. And there's none of those striated lines that you see on the test fire, which you would expect to see in a lander groove impression on the right at all. So again, no microscopic marks of value to compare whatsoever.
All right, how about the bottom photo? And again, the question, areas of disagreement.
The possibility of an area of disagreement maybe in the middle there on the 6A is a line that does not look like it carries over, but just from this snapshot, I cannot say if I had moved the photo a little bit different or the specimens together that area would be agreement. In this photo, it does not look like it does though.
Okay. And could you go to the next photo, please? Same question here, areas of disagreement.
The way this photo was taken is highlighting more of the lack of microscopic marks of value. If I had pulled the specimen that's on the left, the test fire over, there might be some agreement that could be observed, but the way the photograph is now, you don't see the line on the right going all the way over. But again, this is just a snapshot of one particular area.
Doesn't show areas of agreement or disagreement.
There is an area of agreement at the very bottom of the photo.
Okay,
Correct, yes.
next photo, please. How about this one?
This is another zoomed in of the previous photo, focusing in on that bottom area of agreement. So we went from 30x to 40x and just highlighting one specific area, and this is showing you agreement.
Next photo.
So again, this area that is highlighted, the bottom portion that's in focus is showing an area of agreement. As you go up, the lines are a little bit blurred on the 6A bullet jacket fragment. So it's hard to say if that area was an agreement or disagreement. That's not what my photo was focusing on.
All right, next one.
So again, this is going to show you part of the groove impression at the white index. On the top, you can see some striated lines, or excuse me, more of the middle of the photo. The top of the groove impression from the 6A, you see some lines do not appear to be on the right side either, but this photo is also trying to show the lack of microscopic marks at all towards the bottom of that groove impression.
Okay. But there are in these photos areas of disagreement as well as areas of agreement, correct?
In the photo that we just looked at, it could be possible areas of disagreement. Again, it's just one area that I'm looking at. It's hard to tell when you can't look at the entirety of the land in this moment.
Now this, you can take that down, please. Do you keep up with the literature relevant, scientific literature relevant to your field?
I do, yes.
And are you aware of certain criticisms that have been leveled against this AFTE theory of identification?
I have heard, yes, I've heard recommendations on how to improve the AFTE theory of identification, yes.
Well, the criticisms have gone beyond that, right?
Specifically, what are you referring to?
Well, you're aware that the National Resource, the National Resource Council,
The National Academy of Science?
National Academy of Science,
Yes,
is that a pretty preeminent scientific organization in this country?
yes.
Did they conclude in 2009 that, quote, a fundamental problem with tool mark and firearm analysis is the lack of a precisely defined process? As noted above, AFTE has adopted a theory of identification, but it does not provide a specific protocol. It says that an examiner may offer an opinion that a specific tool or firearm was the source of a specific set of tool marks or a bullet striation pattern when, quote, sufficient agreement exists in the pattern of two sets of marks. It defines agreement as significant when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. The meaning of exceeds the best agreement and consistent with are not specified, and the examiner is expected to draw on his or her own experience. This AFTE document, which is the best guidance available for the field of tool mark identification, does not even consider, let alone address, questions regarding variability, reliability, repeatability, or the number of correlations needed to achieve a given degree of confidence.
I do remember
Objection,
there's.
objection. We're now firmly into 702 territory. I object on grounds of relevance to the probable cause hearing beyond the scope of the PC hearing, as I previously objected.
I think it goes directly to reliability. That a scientific group studied this exact process that she used in this case and reached that conclusion.
If you would, so again, I'm trying to keep us on the probable cause standard. This is going a bit deep in regards to it. This is citing to 2009. And so we're in 2026. And again, I don't want to have to dive deep into areas trying to determine, because I feel that we are exiting the orbit of probable cause. If I'm having to make that analysis and trying to see, like, how is this relevant? How does this apply? How does this go to probable cause? So if you wish to ask this question and then move on, we certainly could do that. But
Sure. The only thing I wanted to do was establish that this was the foundation criticism in 2009. And I know when we had raised this issue with respect to one of the other experts, the comeback was, oh, well, this was in 2009 and the PCAST report was in 2016. In this particular field, these criticisms have started in 2009, but they have continued up to the present day and have gotten more strident. So I think that's the take home here, is that this is not some past criticism that has been set aside. This is a criticism that this expert is aware of and that has continued in the literature up to the present time.
But I don't have that second portion of what you just said in front of me. So I can't agree with you, because what I have is what's before me.
Right.
I can't go searching myself as a magistrate for probable cause. I have to take what you say as it is. And if I have to start searching, I've left the universe of probable cause.
I agree. And I was offering that to the court as a proffer in
Okay.
terms of where this line of questioning is going, so the court can understand the context. It
Okay.
isn't just an isolated criticism, and I'll establish with a couple of questions that it's continued up to the present time.
So I will overrule the objection, but I will limit you to this question. We're going to more and more and more. I see your point. You're looking at whether this science is challenged or not. The point's been received, but anything further goes outside of probable cause. So we have to get back on the path.
Got it.
Thank you, Mr. Burke.
You're aware of that criticism, right?
Yes, I am.
And you're also aware of the criticism leveled in 2016.
Counsel, I just said that we're focused solely on, I've accepted what you've said, but I said that it's limited to this question and then we're moving on, because anything further is going outside of probable cause.
I misunderstood. I apologize to the court.
And I
thought-
apologize if I wasn't clear on that. So maybe it was my error not communicating. I've accepted that coming in. I've overruled the objection, but I said we're gonna leave that where it is and then move forward.
And that's where I'm unclear. When the court says move forward, no more questions about any further criticisms beyond that one? If that's,
On this line of question, that's correct. Because
Okay.
Thank you,
All right.
Mr. Burke.
and I think I've made the proffer in terms of the relevancy of it. The
And I
court is-
accept that. So thank you,
Thank
Mr. Burke.
All right, then the last area is, in the years that you've been doing this testing, is it true that you've only taken one proficiency test that involves bullet comparisons?
Yes, I've only had the opportunity to take one bullet proficiency test so far.
And is it true that that was in 2023?
I don't remember the exact year, but that sounds correct, yes.
Right. And is it true that that proficiency test involved a test where you had question bullets and then you had two sets of bullets, one that was fired from one gun, not the suspect gun, and then a second gun that was fired from another gun?
I don't remember the exact final ground truth answers that were there. No, I'm sorry, I don't remember.
I think when you and I talked about this, you said you're aware of a controversy about that particular test, correct?
I was aware, yes, of the results of the proficiency test, yes.
That there was a very high error rate in that particular proficiency test, right?
There was a higher error rate, yes. However, my answers were satisfactory along with the 5 other examiners at my specific laboratory that took it as well.
Your conclusion in that case was, as in this case, that it was inconclusive, correct?
Correct.
Even though the correct answer was that the bullets did not come from the question. The two did not match. The known in the question should have been an elimination.
The ground truth answer was yes, they were excluded. However, an inconclusive result in this comparison was extremely appropriate. The lack of quality and quantity of those individual characteristics never reached sufficient agreement, nor did it ever reach sufficient disagreement. So saying anything but inconclusive was not appropriate.
I see. And can you have bullets fired from different weapons that can have individual characteristics that look pretty similar?
There is occasions, yes, that tool marks that are made by two separate tools are similar, yes.
Could you go, and this is my last area question, Exhibit 19, page 26?
Your Honor, I'm requesting
Page
20 minutes
26.
for cross-examination. We're coming up on 4:37. That would be my request, Your Honor.
That's my last question. So
All right, Mr. Burke. Thank you, Mr. McBride. I appreciate the heads up.
in your opinion, does this, the one on the left and the right show matching individual characteristics?
Counsel, has this been admitted? Because I see it displayed. I just want to make sure, is this? Also-
It has not been admitted, and
Okay.
I'm asking this question and as a foundation for admitting it.
Okay, that's fine. So I just,
Yeah.
it was on another screen. I wanted clarification. So it's not on any screens because it hasn't been admitted, but it clearly can be on her screen.
Thank you.
So only to the witness and counsel table screens.
Page, Exhibit 19, page 26. Does this comparison show individual characteristics indicating that it was fired from the same weapon?
There are individual characteristics present, but without examining it in person, I don't feel comfortable making a conclusion.
Okay, how about the next page? Watch, 27. How about that one?
Again, I see individual characteristics. On a very first glance, I can see maybe one striation that is an agreement, but without seeing it physically in person and having an accurate representation of the entirety, I can't conclude in any answer.
And the last one, the third photo, page 28. Page 28. Exhibit 19, page 28. Same question.
I do see individual characteristics. I do see some areas of agreement without looking at it further. I wouldn't make a conclusion. It's a holistic approach when you're examining items.
Would it surprise you if I told you that all three of those were fired from different weapons?
Again, I don't know any context to these photos other than what you showed, so I don't feel comfortable saying one way or another.
Thank you.
All right. Mr. McBride.
Good afternoon.
Good afternoon.
Those last three photos that you were shown, had you seen those before?
I have looked at them probably back in 2024 when it was published.
Okay, that's a study. Is that what that is? Some sort.
Yes. It was a look from the Association of Firearm and Tool Mark Examiners. It was a volunteer of photographs of people that did have an incorrect answer in that proficiency test.
Okay. And when you do an examination or a comparison, are you limited to one photograph?
No.
You actually have the item in front of you, correct?
That is correct, yes.
And you can manipulate it, you can turn it, you can look at every angle and every side of that item as you do the comparison. Is that correct?
Yes, that's correct.
And as you're doing that process, you're looking for as many characteristics that match or agree or disagree as you can possibly find, correct?
Yes, it's a holistic approach. If I have a bullet like this case, I'm looking at every single land, every single groove impression, and doing an evaluation of each one of those, looking for areas of agreement and disagreement before rendering a conclusion.
Would it be responsible for you to reach a conclusion based on a single photograph of a very limited area of two bullets?
I would not feel comfortable doing that, no.
Okay, I want to back up. How long have you, first of all, where do you work?
I work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
How long have you been there?
A little over 6.5 years.
Where did you come from? Where did you work before that?
Prior to working for ATF, I was a latent fingerprint technician, recovering latent fingerprints from improvised explosive devices. And I also worked as a crime scene investigator in Winston-Salem, North Carolina, and Anne Arundel County, Maryland.
How long did you have that position?
I think cumulatively it was about 5 to 6 years.
And before that?
Those are the only ones. I think it was about 6 months as a latent fingerprint technician, 2 years as a crime scene in Winston-Salem, and 3 in Anne Arundel County.
Do you have education and training before that position?
Yes, I have a Bachelor of Science in Forensic and Investigative Science from West Virginia University, and have attended and graduated the National Firearms Examiner Academy, as well as done specific training at my laboratory.
At each of the positions you've held, have you had on-the-job training at the laboratories where you've worked?
I have, yes.
And will you describe what that training is like at the ATF where you are now?
Yes. So part of becoming a firearm and tool mark examiner for ATF was attending the NFEA, the National Firearms Examiner Academy, which is a year-long intensive comprehensive training program. I learned about historical cases, figures, and the evolution of firearms, fired ammunition components, and manufacturing. And phase 2, I worked 16 weeks of hands-on experience assembling and disassembling firearms using a comparison microscope, comparing fired ammunition components and tool marks, going on manufacturing tours, and participating in moot court. I worked on an independent research project and 4 practical exercises, and then presented that independent research project to a panel of experts, and participated in 2 moot court sessions on 2 of those 4 practical exercises. Then specifically for ATF, I still work on my training, going through practical exercises and competency tests, working under trained firearms examiners at my laboratory, and also continue learning about any manufacturing evolutions or going on manufacturing tours. And I also participate in moot court for every single competency test that I work. Once all of that is complete, then I work on supervised case before moving on to unsupervised casework.
And supervised casework means what?
It means that the author of the final report will be a different examiner, but I am working on all of the work side by side and going through all the steps that are needed for that examination.
And in that process, you're having discussions and discussions about your work with a more experienced examiner.
Yes, it's an opportunity to work a case that has come into the laboratory, but still have someone there making sure I feel comfortable with everything and following every step necessary.
How long ago was that you had that, that you graduated from that supervised work?
I believe that was in 2022 or 2023. I'm not sure.
Do you supervise now others?
I do not have a supervisor capacity, but I have had the opportunity to now teach at the NFEA. I've been fortunate enough to participate as an instructor in the test firing module, the mini moot court module, and the comparison of bullets and cartridge cases.
Are you required to undergo continuing education in your position?
There is not a specific continuing education program. However, when the opportunity to go on AFTI's annual conferences and it allows it, I will go to those, as well as continually go to manufacturing tours.
Is this an area of science and forensics that is continuing to develop new techniques and advance in research?
Yes, it is.
And how do you stay up on those advances?
Part of the way to do that is to continue my membership with AFTI. Again, they do an annual training seminar recently, just in May of 2026 here in Baltimore, where there's case searches and studies that are presented, different manufacturing techniques, just new and upcoming research that is throughout the community, not just firearms practitioners, but also standard and technology researchers like those from the National Institute of Standards and Technology, or NIST.
And I think Defense Counsel has asked you a little bit about some of the publications that have given criticism is how he's phrased it, but given recommendations on how to improve the science in your field. Are you aware of that?
I am, yes.
And is there an effort to adopt those suggested improvements where they have merit?
Yes, AFTI especially takes those recommendations very seriously. if the PCAST asked for more specific design test studies, they said, yes, we will do that. I can think of just a few right off the top of my head that has satisfied those asks that they wanted.
Is your laboratory accredited?
It is, yes.
What does that mean to be accredited as a laboratory?
And accreditation means that my laboratory is held to an international standard of reporting, testimony, training, and proficiency tested. We have a large audit every 4 years through ANAB, or the American National Standard Institute, National Accreditation Board, but we also do internal audits, and we make sure there is some type of audit that we are staying in within those accreditation limits every single year.
There is a mention of proficiency testing. Are you required to do proficiency testing?
Yes, I am.
And are those specific as to what type of proficiency testing that you do?
Yes.
What are some examples?
We are required to take proficiency tests in all discipline that our scope enables, so serial number restoration and the comparison of tool marks, bullets, and cartridge cases.
Are there similarities and principles that apply to all aspects of tool mark analysis and comparison?
Can you elaborate on the question, please?
Well, let's say you're comparing what we've been talking about here, rifling on a bullet. Are the principles that apply to that area versus that also apply in tool marks analysis, say of impressions of a handheld tool?
Yes, all of those comparisons are a product of a tool mark comparison. A firearm is nothing but a tool. So when you are talking about a cartridge case comparison, it's still looking at a tool and a tool mark. The tool in this case is the firearm. The tool mark is being left on a cartridge case or a bullet.
I want to draw your attention to Plaintiff's Exhibit 32. Thank you. Well, that's pulling up. And this has been published, this has been approved for publication at all 3 levels already, so we can put that on the screens. Well, that's pulling up. Thank you. I want to ask you first about an entry here. The second sentence under results of examination. Exhibit 1 is rifle was test fired and found to be in operable condition. Did you perform that test fire?
I did, yes.
How did you receive this firearm?
I received it from another physical scientist in our laboratory.
Okay. And did it have a scope on it?
Yes, it did.
What did you do to determine if it was in operable condition?
In order to determine if the firearm is in operable condition, I will find ammunition that it is calibered for. In this place, it was 30-06 Springfield. Load that into the firearm, and then I fired any test fires into our water recovery tank.
Okay. And why did you choose a water recovery tank?
The water recovery tank is what is used to obtain bullet specimens. The water is going to slow down the bullet from its movement so that we can actually obtain the bullet, and it is supposed to cause minimal damage.
Why does it matter if there's minimal damage or more damage?
You would like minimal damage because that means that there's going to be less damage on the areas that you need to compare. In
the evidence rounds that you, or in the bullets that you often receive in your cases, are there cases where there's a lot of damage to those bullets?
I have received cases with lots of damage to bullets, yes.
In this circumstance, Exhibit 1 rifle, this Mauser 98 30-06, was it an auto-loading rifle or a bolt action?
This was a bolt action rifle.
Exhibit 2 cartridge case. Let's see here. If you'll turn to page 2, and we've already read this line. I think defense counsel read this line to you, the Exhibit 6A paragraph there. The result of the comparison was inconclusive. Could further testing be done to try and see if there is any, if you come to a conclusion on this round?
There was no further testing that I could do, no.
Is there further testing that could be done in the field?
There is the possibility of using a 3D system to visualize the individual characteristics on the bullet.
Do you have the capability of doing that at your lab?
My laboratory currently does not have that capability.
Do you know if the FBI lab does have that capability?
I believe they do.
Defense counsel put up a list of potential firearms that could have fired this round or this bullet. Is that list comprehensive?
It's not an all-inclusive list.
And does it mean that this round, I'll leave it at that actually. There's been some discussion about the 6A bullet jacket fragment. Will you describe what a bullet jacket is?
Yes, I do have a demonstrative. May I use that?
Do you have that with you? Yes. Yes, please go ahead.
So this is a demonstrative of a bullet. So a bullet jacket, it would refer to the outside of the bullet. Inside the bullet would be the lead core. So when I'm referring to the jacket, it means that I've only received that outer portion. I did not receive any of the lead core intact with it.
In this circumstance, you received a bullet jacket fragment. What does that mean that it's a fragment?
Fragment means I don't have the entirety of that jacket.
And can you testify as to why you don't have that entirety?
No, I cannot.
And it also, your report also says that there are 4 lead fragments. What is this? Why would you have lead fragments?
So the lead fragments, the lead would be from the inside of the bullet, that core. Occasionally when the bullet reaches its final destination, it can split and some of that core might be pulled off of the jacket and be found where it landed.
And would you be able to gather information from those lead fragments that could identify them as coming from this particular firearm? Would you expect to be able to make that comparison?
I would not expect to see any characteristics that would help me reach a conclusion, no.
Why not?
Because the lead core is on the inside of the bullet, the landing grooves are going to be imparted onto the jacket or the exterior. So when it's moving down the barrel, the inside is not coming into contact with rifling whatsoever.
Hey, Steve, can we go ahead and get some questions and pause
In this
this right
case,
here?
do you
We
have a
can wrap this
verification
up.
step where your work is reviewed?
All
Absolutely.
right. Sorry, go ahead, Steve.
Absolutely. I have a feeling she might go overtime because they're saying they don't have her again after today.
Correct. And okay, so basically what was happening here is the defense called her. The whole point is to call into question whether or not the bullet fragments that were recovered actually came from the rifle they recovered, and basically saying that her report said it was inconclusive. There wasn't enough information or data points to say that there were sufficiencies, or I'm sorry, what did they actually say? Their standard. There weren't sufficient marks. There weren't enough sufficient data points to say that the two things were compatible, but there also wasn't enough dissimilarity. So really was inconclusive. So now the prosecution is trying to rehabilitate her testimony. But I know there's been a lot of questions and things on the chat, so I want to answer a couple of those before we get out of here today.
Just amusing from Edward Mismas. She gets to play with guns, totally jealous.
Yeah, that's her job. The
Also
woman is
how
accomplished.
accomplished she is. Angelica
She is.
wanted to point out that the defense attorney is kind of leaving a bad taste. And I think the broader question is, do you think he intentionally pushed too far on the handbook, I think it was?
Yeah, I think that they don't have much to work with. I'm being honest with you because it was hard for me to follow a little bit. Like, all right, I'm trying to figure out his strategy. Where is he going here? And the judge kind of explained that. Like, look, this is just a probable cause hearing. You're going way too far. You're doing way more than is necessary. Your point has already been proven pretty much. And I think that he did do a little bit too much, and especially because well, then again, they only have this witness today. However, I do feel that he made his point, and once you make the point, move on, because the rest of it wasn't going to strengthen it. Yeah. But thank you for the questions. Thank you everybody for tuning in. Yeah, the magistrate is getting agitated, understandably. Yes, I agree. Again, this is just a probable cause hearing. However, this is extremely high profile and it is being televised. So I understand that this carries a little bit more weight. And, some attorneys, they definitely are performing for the public. Yeah.
On that end, I think we should talk very briefly about the comments the defense attorney made about Erica Kirk having access to information.
Oh, correct. So basically what is happening here is the victim's family, Erica Kirk, their wants differ from the state a little bit. They want everything public, everything transparent. That's understandable. However, this is not the trial. This is a probable cause hearing. And so the state, while they generally favor transparency, they don't want as much transparency as the victim's family, as Erica Kirk, because the point is they don't want to possibly taint a jury pool. And so they need Tyler Robinson to have a fair trial. And if all of this evidence is put forth, it's going to be difficult to impanel a jury that has not seen any of this, which is why the defense, from their side, they would prefer that even less is made public, if anything. But that's really what this comes down to, is preserving the integrity of the jury pool for when this goes to trial. And the victim's family, they want everything out now. And, if a jury already sees this stuff and they have their minds made up, behooves the prosecution or the victim's family. But however, it doesn't if it impacts this trial, and then it makes it difficult to impanel an impartial jury. So that's really what was going on there. It's a careful balancing act because the magistrate is trying to please everybody. He's trying to help and be sympathetic to the victim's family while also preserving the integrity of the judicial process. Yeah. But, thank you everybody for tuning in, and we will continue to follow this. And so look forward to more analysis. And I believe they have at least one more day tomorrow. So it'll be interesting to see what shakes out then.